Well, welcome everyone. Thank you so much for attending in person and online and out there watching this as a recording. I'm Rick Hasson of UCLA School of Law, and together with Nate Persily of Stanford, we've convened this conference. Nate of the Stanford Cyber Policy Center. I'm coming from the new Safeguarding Democracy project at UCLA, and this is really a topic that brings together those who are concerned about questions of democracy in the internet, and also those concerned about risks to free and fair elections in the United States and around the world. And so the topic is, should Donald Trump be returned to social media? For those who are not as familiar with the topic, where things stand right now, Donald Trump has been removed from Twitter for an indefinite period. That could change if the sale goes through to Elon Musk, who's indicated he might restore Trump to Twitter. At Facebook, following decisions of the Oversight Board, Trump's suspension lasts until January 7th, 2023, where the question will be revisited, and we'll be hearing about the criteria for all of that later today. So this is very much a live question. Other platforms are considering questions like this. And so we've gathered together a group of people, both here in this room at Stanford and also online, to talk about this issue from various perspectives. We have First Amendment scholars, human rights scholars, scholars who study the internet, people who've worked in the field on these issues. And it really is a great group. The way we're going to proceed today is we've got a series of questions that we're going to pose, and just to try to have the discussion be structured. First, Nate Persily is going to do a little introduction to all of the issues. And then we're going to we've broken it up into five questions, and I'll tell you each question as we get to it rather than give you them all now. But we've divided up the panelists who are here today and asked each panelist to be responsible to speak for 3 minutes on one of these issues. So we'll hear from 2 or 3 panelists on each question. And we do want to invite those who are watching. We know people who are watching, or some of you work for the platform, some of you are involved in these decisions. We're going to use the Q&A feature to be able to include your comments and questions in our discussion. So please feel free to use that. And with that, let me just ask everyone we'll go around the room, starting with Evelyn. Just say who you are very briefly, your affiliation, and how you come to this issue in a sentence or so.
Hi, my name is Evelyn Dueck. I am an assistant professor at Stanford Law School, also affiliated with the Cyber Policy Center here. And I come to this as an academic who has worked on online speech governance, First Amendment issues, and also international law.
Hi, I'm Genevieve Lakia. I teach law at the University of Chicago Law School, and I feel a little bit like an interloper because I'm really a free speech person, a First Amendment person who started to work more on statutory free speech protection. But I've long been interested in that domain, in the question of private power and how you think about private censorship, private oppression of speech in light of free speech principles. And that ineluctably drew me into the strange new world called social media. And here I am today.
I'm Renee DiResta. I'm the Technical Research Manager at the Stanford Internet Observatory. We study use and abuse of current information technology. So we have a lot of work that we do on understanding trust and safety and mis and disinformation, as well as policies that govern it, both at a regulatory level and a self-regulatory level. I am not a lawyer, and so been intrigued by reading everybody's much more legal-focused opinions on this, as opposed to mine, which I think comes from perhaps a bit of a different place.
Great. I'm David Kaye. I teach law at the University of California at Irvine. And for 6 years, up until 2020, I was the UN's special rapporteur on freedom of opinion and expression, and did a lot of reporting on technology and free speech and privacy and so forth. I'm also the chair of the Global Network Initiative, which is a multi-stakeholder group of companies and NGOs, academics, and investors who are really looking at these issues, typically in the context of government demands, but maybe that's changing a little bit. And I'm also on the board of Article 19, which is a sort of like I think it was a Human Rights Watch of freedom of expression.
I'm Eugene Volokh. I teach at UCLA Law School. My first career for 12 years was as a computer programmer. So when I went into law teaching, which is now 1994, one of my first articles was on, I guess we called it cyberspace law at the time. People toying with Infobond, which turned out to have been a mistake. I've been mostly a First Amendment guy since, but obviously it intersects a lot with technology law, especially with regard to internet law. So I've been writing pretty extensively about that for quite a few years now.
I'm Daphne Keller. I direct the program on platform regulation here at the Cyber Policy Center. I was also a lawyer at Google for 10 years. I was the associate general counsel in charge of web search, so I decided what came down there. But both in that job and in my role here, I'm really interested in when the law compels an answer to questions like these, or could not, for constitutional or human rights reasons. And so that things that are anchored in the law are more my angle than things that are anchored in what companies might choose to do exercising their discretion.
You want me to introduce myself? Or?
Sure.
Okay, sure. I'm Jake Schlesinger. I'm on a leave of absence from the Wall Street Journal's Washington Bureau here at Stanford for a year at the Distinguished Careers Institute on a fellowship doing intensive study on democracy issues. And I've concluded that the best way really to do that is to show up for anything that Nate personally sponsors.
I'm Guy Charles. I teach at Harvard Law School. I write mainly about law and democracy, and also increasingly starting to think about social media and its relationship to race and racial equality.
Hi, I'm Katie Harbath. I'm an independent consultant right now, working with organizations such as the Bipartisan Policy Center around issues of tech and elections, and I've got my own company, Anchor Change, in doing that. But why I'm here and what brought me here is I spent 10 years at Facebook, where I built the teams that work with politicians and governments on using the platform and coordinated the company's work on elections from 2013 to the end of 2019.
I'm Eli Sugarman. I'm a fellow at Schmidt Futures, and so I'm thinking about the role of philanthropy and content moderation, trust and safety, and supporting all of the important work of folks around the table. Before joining Schmidt Futures, I was at the Facebook Oversight Board, where I led the staff teams that did a lot of the core work with board members on all cases, including the case involving former President Trump's account. And so I'm coming at this from a perspective of thinking about the role of the Oversight Board, governance models, and really what the future holds now that I'm no longer formally affiliated with the board and looking to learn from everybody who's here today.
I'm Katie Fallow. I'm a senior counsel at the Knight First Amendment Institute at Columbia University. I've been a free speech and media law litigator for, I guess, over 20 years, starting in private practice, then in the Federal Trade Commission, and now with the Knight Institute. And I come at this from a litigator's perspective, so it's very legally bound, and from the perspective of the Institute, where we have worked on a number of cases, including where we sued Trump when he was president for blocking people from his Twitter account. So particularly on the government's use of social media and the First Amendment restrictions and implications, but interested more broadly in the speech environment, including not just legal restrictions, but public policy issues.
Hello, I'm Chinmay Arun. I'm the director of the Information Society Project at Yale Law School. I work on social media questions, and I've been doing so for the last 4 years in the United States with support from many of the people in this room and at this table. But before that, I used to teach law in India for 10 years, and I used to run a research center similar to the Information Society Project with a slightly more policy bent over there. And that means that when I work on social media platforms, I'm interested in them from a global point of view, and specifically from a point of view that takes into account power. You'll see a little bit of this in my last article called Facebook Spaces and Harvard Law Review Forum, but I'm still working and I'm still teaching this.
Yeah, do you want to introduce yourself?
Nate Persley, I'm the head of the Cyber Policy Center and a law professor here, and work on a lot of these speech and tech issues.
Marianne?
Hi, everyone. Marianne Franks. I'm a professor of law at the University of Miami School of Law, and also the president and legislative and tech policy director of a nonprofit organization called the Cyber Civil Rights Initiative. I'm primarily interested in the intersection between civil rights and technology, the question of how online abuse can be used to silence and harass individuals, especially vulnerable communities. And I also work extensively with many tech companies, social media platforms, to help develop their privacy and safety and free speech policies.
Jonathan.
Hi there, I'm Jonathan Citrin. I teach law and computer science at Harvard, where I helped start the Berkman Klein Center for Internet and Society. As a teenager, I was a sysop on CompuServe, a pre-internet proprietary information service, where issues of content moderation also loomed large, and I felt as anchorless then as perhaps some of us feel today. And from the land of Zoom, I convey a plea among the currently 82 people online that people in real space speak more loudly if they can.
Oh, good to know. Thank you. And when you two want to participate in, as we ask the questions, use the hand raise function, then we'll be able to see it on the screen. We'll put in the chat a link to we asked people to write up to 5-page position papers for today. And so we'll put a link in the chat so you could download those papers, as well as the PowerPoint that Nate has pulled together. And before I turn it over to Nate, I just want to thank Michelle, I'm pronouncing your last name right, Poulan, who has just done an outstanding job pulling together this conference. It wouldn't have happened without her, and we really appreciate everything that she's done. And with that, let me turn it over to Nate.
Okay. You're plugged in. Yeah, that should be okay. Able to be seen by everyone? Okay. First of all, I just want to thank everybody for coming. This is an elite group of folks that we have around the table, and you know, we couldn't ask for a better crowd to investigate these issues. And I'll say that the motivation for that, we thought maybe 6 months ago that we would have this conference, and really didn't get our act together. I think it's the ever-present energy of Rick Hasson that was able to, you know, have us cross over the finish line here. So Rick, I really appreciate the energy that you put into this to get it all off the ground. I thought what I would do is I would just try to introduce what I think are the main issues, the way at least I'm thinking about this question. And I want to be clear, I have a pretty open mind on this issue. I really do think, you know, I hope that we'll have a real diversity of opinions around the table, as is happening at the platforms and people in decision-making capacities, where I think that, you know, they're really wrestling with this question. If one were to buy a social media platform, maybe you wouldn't have to wrestle as much with the content moderation teams and the like, but I think right now the people in power are really wrestling with it. So let me just start by saying that I don't think there's any easy answer here. And actually, Ben, I'm going to have to ask you to come up here because I'll look on the screen this way. There's no easy answer, right? So that it seems to me that there's two choices. You know, either we're setting a precedent here that platforms are going to be able to restrict their service to one side potentially of a presidential campaign, a precedent that would not just be limited to the United States, but of course have impacts around the world. And then there is, as I think Rick aptly put it, there's the possibility of this existential threat to American democracy, which is looming out there. And so, you know, whichever side I think that you're on in this question, and I think there are some middle grounds that I'll talk about at the end, we shouldn't assume that this is an obvious answer to this question. Ben? Okay, let me just put a few things out there to start, which is that, I mean, I think we've got so many free speech and democracy scholars around the table, but we shouldn't assume that those are like the only interests at stake if you're working at one of these private companies. And I don't think those are illegitimate bases by which to make this decision. If this results in boycotts of the companies, if this leads to a flight of advertisers, those are, I think, legitimate factors to consider. Those are not ones that I'm talking about, and I think many of the people around this table, when we'll be focusing on the democracy and speech factors. Second, as I mentioned in the first slide, that this is a primarily US focused crowd here, but the decision both to deplatform Trump and then whether to replatform him has implications around the world. And whether thinking about Bolsonaro or Modi or other democracies or stressed democracies or authoritarian governments, how to think about the relationship of these platforms to political leaders is, I think, a very difficult question. And then how to think about the context of this Trump deplatforming and potential replatforming in that international context, I think, poses some difficult questions. Third, it is not readily apparent to me that the same standards should apply to all platforms, either because of their size, their affordance, or the danger that they might pose in terms of the existential threat to democracy that Rick was talking about. And so I think we should, one thing that I think has gotten lost in, I don't know, the commentariat on this is that actually the platforms had different bases for taking him down. And so we shouldn't assume that maybe the reinstatement should always be driven by the same principles in each one of the platforms. Fourth, and this is my kind of hobby horse, which is that I think First Amendment jurisprudence, and we've got a lot of First Amendment experts around the table, it's only useful insofar as we talk about these issues in these cases. That I get very frustrated when someone says, well, Brandenburg says that we should, that this wasn't sufficient incitement. I actually agree with that, as I'll say in a moment, that I think that the speech that led to his deplatforming probably is not the kind of speech that a government could punish under the constitutional test. That's interesting, and we can talk about it, but I think ultimately the decisions for the platforms are not like, well, what would the Supreme Court say? The final, maybe more controversial point is I actually think, and this was not necessarily the way I would have thought at the beginning of the sort of deplatforming, that censorship has actually worked, which is that it had a much bigger effect in terms of Trump's ability to reach an audience. Truth Social, while maybe growing, has not replaced Twitter in terms of his ability to reach an audience. We go back to the first question. Let me just start with the first question. And the first question, I just want to do a little sort of scene setting, because there are some people who believe that all of the content moderation standards that these companies have are illegitimate, right? And that you should never be able to deplatform anyone, that these are public squares. And so the idea of kicking someone off of it is sort of totally anathema. I reject that, but that I want us to reckon with the fact that there is that school of thought is out there, that deplatforming because of hate speech, because of incitement, other kinds of violations of the community standards is not seen as legitimate. And similarly, that that some would say that the deplatforming for the kind of speech that Trump engaged in also is not legitimate. That kind of, whether it was political speech, whether it crossed the bounds to incitement or not, I don't know. Ben, I'm going to need you to stand up here because this is not working. Mm-hmm. Okay. All right, let's just do it this way. That's all right. No, I'm just going to do it. All right, so let me just point out what the different platforms, which speech actually led to the deplatforming on each one of these platforms. So for let's actually start with Twitter. Twitter's explanation, right, was that these tweets, The 75,000 great American patriots who voted for me, America first, and make America great again will have a giant voice long into the future. They will not be disrespected or treated unfairly in any way, shape, or form. To all those who've asked, I will not be going to the inauguration on January 20th. And obviously, this is not by its terms inciting speech, incitement. But seen in context, and Twitter had more information than just these tweets to then describe why it was taking him down, as well as, of course, the whole history of his tweeting up to that point, then led to him being kicked off the platform on January 6th. Facebook. It was their dangerous individuals and organization policy that was violated by the video that Trump put out. Said, I know your pain, I know you're hurt. We had an election that was stolen from us. It was a landslide election. Everyone knows it, especially the other side. We have to go home now. We have to have peace. We have to have law and order, right? And goes on, continues to say that this is a fraudulent election. Says, so go home. We love you. You're very special to the people who were committing the insurrection. And then as the police were securing the Capitol, he wrote, these are the things and events that happen when a sacred landslide election victory is so unceremoniously, viciously stripped away from the great patriots. Okay. YouTube, there were so many YouTube videos that I think that it's hard to figure out exactly which one may have crossed the line here. But YouTube on its Twitter page, and then later with an interview with the CEO of YouTube, Susan Wojcicki, that you had the explanation was that after review and in light of concerns about the ongoing potential for violence, we removed new content from Donald Trump's channel for violating policies. And then given the ongoing concerns about violence, we'll be indefinitely disabling comments. And then they disabled his account. And later it was confirmed that of the standards that were violated, it was the kind of incitement prong of their violent and graphic content standard. Okay. All right, so that's the speech, and I, for the First Amendment folks around the First Amendment professors around the table, I think it is hard to put that kind of speech into the typical incitement box that we usually use. But of course, it's seen in context, and I, for one, on January 6th, you saw what was happening. It seems like a perfectly reasonable step for the platforms to take. Question 3: how should so if you disagree, or if you answer those first 2 questions no, then you think that then Donald Trump should be on, so should have been never taken down and shouldn't be and should be reinstated now. The third question, and this is I think a really hard one, is how should Trump's actions and speech since the deplatforming bear on whether he is replatformed, right? Is this, to the extent, there are some people who might have thought, well, look, maybe even the initial deplatforming was a marginal decision, it was a close call. But how about speech since then? Because it's not as if it's become different in character when he's been saying, whether it's on Truth Social or publicly. So could a platform try to predict, in a sense, what will happen if he is returned, so that based on the history over the last 2 years, could they take that into account? Not just his speech on, say, Truth Social, but also his offline or off-platform alt-platform speech, like on these other platforms. And one thing I want to just tee up is that the kind of speech that he's engaging in is ubiquitous on the platforms already, right? So what he is saying on Truth Social or in public is happening on these other platforms. And so the question is, all right, so why should he be treated differently? It has to be because of some additional risk that he poses, right? And that leads to question 4, which is, I think, the most critical one. If there was cause to take him down on January 6th, if we agree with that, or if one agrees with that, have conditions changed on the ground such that his replatforming no longer makes violence likely? And here is where I'll say a few things at the end on this, but the January 6th committee hearings this week are clearly trying to put a marker down, saying no, things haven't changed. If anything, they've gotten worse. Half of Americans right now anticipate a civil war. Whether we look at public opinion or not in this case is, I think, a reasonable and open question. But the platforms are going to be relying on third parties to make this assessment about how likely it is that we're going to be experiencing real political violence. I'll say one of the things that I'll end with is that we may wait and let's see what happens in the midterm elections, because it may be that the midterms are going to give us a good sense about how dangerous the situation is. All right, so now the last two questions, which are kind of, if you forgive me, meta questions on how to treat political leaders and treat Trump in particular. We'll talk a little bit about this. Should heads of state, former heads of state, be treated differently? I think there's a big difference in this room. Some who believe, yes, they should be held to a higher standard because their potential for causing violence and reaching an audience and incitement makes them that we should have greater scrutiny of their accounts. Others who think, well, no, they should be given less scrutiny because in some ways that's sort of their speech is core to the political debate, and the risk of the platform biasing elections or biasing political conversation is even greater if they start censoring political leaders. And then the last question, we've posed the question here as to whether Donald Trump should be returned to social media. Why are we talking about that now? And in some ways, it's because the Facebook Oversight Board gave the 2-year timeline and forcing them to revisit it. But also, it's because he may end up being a presidential candidate. And so, if the platforms are availing their audience or making available their audience to only one side of the political campaign, that's, I think, a real question. I put a flow chart in there about how I think that you can sort of go through these this Trump decision tree and what does it mean. But let me just end with what I think are the options for the platforms, because we posed this question: should he be returned to social media? And so, yes, it's possible to just be fully reinstated, and just like any user, it's possible that that will just maintain the status quo either indefinitely or until some kind of criteria are met. But then there's also what I'll call partial reinstatement, which I think seems kind of likely, at least for some of the platforms. The first would be, and here I'm borrowing, I think, on Eugene Volok's really good article in the Journal of Free Speech Law last year, on thinking about amplification differently than presence on a platform. And this was more in the constitutional context of thinking about the platforms as common carriers. But you could envision a situation in which he has a Twitter account, has a YouTube account, has a Facebook account, but that the information, his communication, will not be fed by the algorithm to anybody. No recommendation systems. You'd have to go and search for it. I mean, I still think you'd have a huge audience, but that's one restriction. Same with sort of limiting, sort of partial reinstatement, where he would have maybe not the ability to advertise, not the ability to have certain features on the page, limits on the posts per day, the speed at which they're displayed, even limits on the content or warnings that they would do for, disinformation in particular. I want to throw out there one thing, though, that I haven't heard, but that is a possibility. I don't think the platforms would like it all that much, but that is literally to have a prior restraint that would apply to him, where you would have pre-review and delay of posts. That could also apply to Joe Biden, frankly. I sort of think that maybe there's a good reason to be equal here, as to pre-approve some of these presidential candidate posts to see if they violate community standards. And so all of this could be done in a kind of probationary period where where there's full or partial reinstatement, and then we see how the platforms see how it's going after a few months. All right, but in the end, I think there's a significant bias in favor of the status quo. If you're working at these firms right now, it's not really an issue, or at least you've already suffered the accusation of censorship of the right. It's not clear that you're going to make up much ground by changing the status quo. If it is likely that after replatforming, you're going to end up deplatforming again and inviting even more controversy, it's not clear to me that that's in anyone's best interest. Because there's nothing, as I said, that I think the platforms can do now to counteract the widespread belief in their political bias. So I think we'll be waiting and seeing about violence in the midterms, as well as whether there's a possible indictment, and then the report of the January 6th committee, or if he testifies. But I think now I'll just be an empiricist. As Rick said, I think that it's likely that Twitter will return him if the Musk deal goes through. The oversight board is the triggering event for Facebook's or Meta's decision in January. One thing I kind of would be interested in them doing is putting this back in the oversight board's lap, that Facebook or Meta should come up with its decision and then say, all right, oversight board, is this what you thought? We'll see how welcoming they would be to have that put into their lap. And then lastly, I think there's gonna be a lot of scrutiny of the platform's reliance on these expert assessments for whether the incitement risk is still there, right? Because a lot of these organizations are gonna be seen as politically left and more likely to say that there's increased risk. So that's my attempt at setting the table. I don't know how, Rick, how would you like to proceed?
Thanks, Nate. That was very helpful. So I think we'll go to the first question then. And just to remind everyone, both here and out there, that we've divided this into questions to try to have a little bit of a structured discussion, but we're not going to be all that rigid about it. But rather than start with the question posed by the conference, should Donald Trump be returned to social media, we want to take some more general questions and see if that helps lead us to any decision or our own opinions on this. And for each of these questions, I've asked 2 or 3 people to be the leadoff people to just speak for up to 3 minutes. And so the first question is, should social media platforms ever have grounds for excluding candidates and political figures? And should there be a different answer in the United States than elsewhere? And so we're going to kick it off with Katie Harbath, Chinmay Arun, and Jonathan Zittrain. So let me turn it over to Katie. Katie
Sure.
H, since we have 2 Katies.
Yes, we have a lot of Katies. So I thought that given that we just have 3 minutes at the outset, focusing purely on the question of excluding, because there's actually a lot of exceptions right now, and I think is a different way of looking at it, and we can certainly dig into that as well. A little bit of history, if it's helpful, is at Facebook, when we started putting together the teams and trying to help think about supporting politicians in using these platforms, which actually go back to kind of the 2006, 2007 timeframe is when companies started to do this. We generally had a belief that we would give the state access to the same tools, they would have access to the same customer service, everything else like that, as long as they were allowed to be on the platform. And up until the Trump deplatforming in the last couple of years, the only types of political parties that usually weren't allowed on the platforms were ones like Golden Dawn. Or there was also a difficult question we had at one point in time around Hezbollah in Lebanon during their elections, whether or not you let them on, because they were also a political party, but they were also obviously a terrorist organization. And so the only types of exclusions you really saw were ones that we were trying to make sure that we wouldn't look to be seen as we were giving an in-kind contribution to the candidates, because the FEC was really not clear on this. And we were worried that if we were giving support to one campaign or not another, that then there could be things filed against us and we would have to report those as sort of in-kind contributions. Since then, things have certainly changed a lot. Starting in 2019, obviously we have exclusion of political ads, but that tends to be, it applies to everybody. It does not just apply to some candidates or the other. And I think in general, I still have a bit of a hard time getting my head wrapped around how in the world I would be able to justify excluding some candidates from having access to stuff and others not having access to those same tools, and how we would do that in a way that might not, again, not just potentially violate FEC law, but then just general ethical principles of giving equal access for these types of things. Some of the platforms are trying to not promote political content at all. Facebook has said they're trying to do less of that. TikTok has gone an interesting route where they're also trying to exclude candidates from being able to post fundraising messages on their platforms. I'd be very curious how they're going to enforce that. But that is, all of these you can hear are kind of blanket exclusions that they're they're doing. So I think that is one question of sort of the trickier one is, can you exclude some versus the other? And I have a hard time of how to justify that. I'm just going to wrap up really quickly just to go into the legal concerns a little bit, because the FEC is now not only kind of vague on it, but also I think a little confusing on it, because there have been recent opinions with Twitter and Snap where they have said the platforms have a commercial, they can either because of commercial reasons, or some of the Republican FEC members have said their editorial judgment that they, for instance, Snap, it was okay, they promoted Joe Biden in their, I think their Discover tab and not President Trump. With Twitter, they said Twitter was within their right to suppress the Hunter Biden laptop story. With Google and the email, they said that Google can have their special program for the emails of not putting them into the spam filters as long as it applied to everybody, and that it was out of a commercial interest and it wasn't something that would normally get paid. But what they have not ruled on is whether or not, if a platform, for instance, if Trump is not let back on and he does run for office, do these platforms that have teams like my old one of supporting candidates, can they still support Joe Biden and the Democrats if they are not giving that same support to Donald Trump, given that that is something of value? So I would not be surprised if this also potentially lands in the FEC's lap in terms of a question of what the types of support that the candidates can give and what that means in terms of excluding them or not. And I'll end there.
Thank you. Shemai. Remember, everybody needs to speak up because so they can hear us online.
I was going to say, if I'm not loud enough, please let me know.
Yell. I'm going to move the mic closer to her, actually. Yeah.
Thank you. And so I don't want to repeat the things that I've said in my essay, but broadly, I am team let's keep him suspended. And I'm going to quickly go over why, and then I think focus on the reasons for which this is not an easy question. And there are ambiguities, even though I've gone with a glib, yes, keep him suspended answer. And so my first one is that I firstly am talking about political leaders differently from political figures and candidates. And the reason I'm thinking about leaders is that it implies that there's an audience and a following, and they have an interest in what happens with the political leader. My second reason is that political leaders have power in ways in which political candidates don't necessarily. And I'll discuss why that matters to me a little later. So broadly, I focused on three things. One is the right to speak and the right to access information, which I think most people have discussed. And the way I've treated that is I've said that political leaders usually are able to speak and their followers are able to access their positions in other ways, even if the big tech platforms don't unsuspend them. As Nate has pointed out, it's probably not to the same degree to which people would be discovering and accessing their materials on the big platforms, but it's not impossible. Anyone who is looking can find them. I have a caveat to that, which is that I think that that's very easy to imagine when we're in a country like this, where we're used to taking freedom of expression on multiple media for granted. But I think that the platforms are present in countries in which one political leader can effectively bar another political leader from all platforms. And I mean like the traditional media, pamphleteering, broadcast media, all of it. And I think that under those circumstances, the platforms will have a difficult question before them. And it might be worthwhile for them to think through what they would do when say, the leader of a state effectively bars their opposition from engaging with them in any way. So that's one. Two, which I think is the more interesting question, is that I think we've all gone over the consequences and risks and the idea that a charismatic political leader who can bring about change equally can use that charisma to incite violence. And that is the reason that we're all uncomfortable with Donald Trump being replatformed. But I think that, again, where that line gets blurred a little bit is when we're talking about a social movement. And if you think of Black Lives Matter, so you think about the women protesting in Iran, there's a fringe of the social movement that can end up being violent, and an authoritarian regime will usually focus on the mob violence part to justify shutting down the protest part. And so this language that we use that certain kinds of speeches end up inciting violence is also language that can be co-opted. And I think that again is a difficult question when platforms are making an assessment of whether they want to suspend a leader or not.
parts of this also have to do with context of who we perceive as a threat. And as you know, that varies from group to group. And so there may be people in Iran who perceive women with unbound hair as an existential threat, the same way in which we might perceive Make America Great Again people, I don't want to assume, but as a threat. And so again, there's a stark variation in context. So having highlighted the problems with my position, I'm going to stop here because I think I'm out of time.
Thank you. Jonathan, you're up, and thank you for joining us from Cambridge.
Oh, thanks so much for including me and for convening this conference. I'm really glad that the video is going to be saved, at least I think I'm glad, in part because I have every suspicion we're going to look back on this 10 years from now and just think how naive we were. It's just hard to predict in what ways we will have turned out to have been terribly naive. So I understand in this opening session, you've asked the question, should social media platforms ever have grounds for excluding candidates or political figures? And so I kind of take that almost as like a jurisdictional question, kind of like, should platforms be evaluating this at all, or just have a bright line rule that says not our business, the way that Mark Zuckerberg represented for Facebook? You don't want us evaluating ads for truthfulness, so no matter how bad a political ad might be, Facebook isn't going to get into it. And I see that as kind of an element of an observation I've felt about digital governance these days, which is we just have two problems. One, we don't know what we want, and two, we don't trust anybody to give it to us. Still, amidst all of that, I think it's important to acknowledge just the simple descriptive fact that intermediaries, like the platforms in question here, have a choice. They have a choice, and as Nate observed in his opening slides, maybe with some surprise, I share that surprise, the choice can stick, especially in circumstances with personalities as singular as a public official or a candidate, and deplatforming them can actually have a real world difference. So they have a choice, and that leads to the question of under what circumstances, if any, might they have a responsibility for, I mean, for Trump, it's like 90 million followers he had, and it's Twitter that is connecting him with those followers when he tweets what he tweets. And I, by no means, think that the platform should think of themselves, of course, as standing in the shoes of every person who uses and says anything on them. But there's a great distance between that and saying there's just no responsibility as a moral matter at all. So my temptation then is just to start from a minimum core, like the way that I, back in the day, had very little interest in ICANN deciding who gets a domain name, even if they're coordinating the domain name top-level domain system. But when somebody comes along with Citibank.com, but the second I is a lowercase l, and they're using it to steal money left and right, it seems bizarre that you wouldn't be able in that instance to say, you know what, you're not getting that domain name. And there's, I think, a similar core that we could identify here, and that's already been kind of broached, that has to do with calls for or endorsements of extra legal violence. And in this case, which I think is a live one, it's okay to focus on the person rather than on the transaction, which in this case would be a tweet. Like in a community of humans, we should expect a community of humans that is organized on a platform. I think it okay jurisdictionally to expect like MVD, minimum viable decency, like whatever that bare minimum is. And it can be pretty close to nothing. But if you don't even agree in principle to meeting that minimum, the idea that you would be blessed with a prior restraint and somebody, some poor intern at Twitter, I guess it wouldn't be an intern, would have to like look at each tweet and decide and to pre-clear it. No way. You either commit or you don't. And this is kind of easy because Trump has not committed. He doesn't even say he'll come back if it were offered, much less having asked. And I think Nate highlighted a couple of the tweets here. You know, the hypothetical would be like, I'm calling for the killing of my enemies, but now I'm running for office and therefore my call should not result in my termination. No, you're running for office. That's all the more reason that we should not be, given the impact you could have, helping you with those tweets. And in this case, the one that jumped out to me was Trump's retweeting with approval a video, a very short clip of somebody saying the only good Democrat is a dead Democrat. And that does strike me. And if the roles were flipped, I'm pretty confident I'd feel exactly the same way, that it would be a good grounds for a removal, even under an MVD protocol. And I think it's a bonus that there'll be a Streisand effect for the instance of the removal. It'll get a lot of attention. It makes it harder to do shadow bans or something. There will be a chance to debate it. And in the debate here, there were very few people, even those who supported not deplatforming, who didn't think he should be deplatformed, very few who were like, but you know what, his tweets were great and I support them. There was a kind of sense of like, yeah, he crossed a line. Now, just finally, I think there's a core element of Trumpism and shared by other isms that there can be no principle beyond winning. And I credit that he believes that for himself, and he believes that others only operate on that, and therefore applied to institutions, it insists that they stand aside lest they be accused of bias. All they want to do is win because they are in the tank for X. But I just don't subscribe to that. I mean, law professors and students live, if not thrive, on edge cases. There are plenty of them. Bias can creep in, but that shouldn't stop the articulation of a principle, an attempt to apply it, and possibly, as fitfully shown by a phenomenon like the oversight board for Facebook, there can be external judgments or processes commensurate with the gravity of the situation and the choice. This is way beyond a customer service issue, both in the nature of the judgment and in the power of the major platforms when they choose to exercise their choice. I don't think that's a reason to say there can never be jurisdiction here. Thanks very much.
Thanks, Jonathan.
Let's see if people
What's that?
We'll go around the table, see if people want to jump
Yes,
in now.
right,
Yeah,
yes.
I
So
mean,
now we'll open it up. So
lots of provocation.
we could do this, have people turn their things over if they want to speak, or just raise your hand. Eugene.
So this is very interesting, a very important issue.
Speak as loudly as you can.
Sure. I wanted to raise two questions. One is triggered by what John was saying about, and I think you'd mentioned as well with regard to one of the tweets, about the endorsement of violence policy. And look, I don't approve of political violence from any side. I don't like endorsement of it. But the bottom line is there is a good deal of political violence out there that at least some people sympathize with in some measure. So I want to ask a hypothetical. It's 2024. There is a rerun of some of the riots of 2020, which is to say many peaceful protests, some of which turn violent, some of which turn fairly massively violent with attacks on police stations, courthouses, and such. And some candidate for office says, you know, riot is the voice of the unheard. We should recognize it's not a riot, it's a rebellion, and the good kind of rebellion, not the bad insurrection. This is good rebellion. And, you know, I personally urge everybody to be peaceful, but I so understand the rage and the demand for justice and such. At what point does that candidate get removed? So that's one question. Here's a second question, which is maybe in a sense, flip side or who knows, related. It's as to the hate speech policy. So I'm looking at an NPR survey from late June, and it reports that on one fairly prominent issue, whether male to female transgender athletes should be allowed to compete on women's sports teams. The current, at the time, result was 63% said no, and 24% said yes. Apparently, according to Twitter, the 63% are hate speakers. So, for example, in February of this year, a congresswoman's account was suspended by Twitter for tweeting something that said women's sports are for women, not men pretending to be women. Likewise, Babylon Bee, a prominent kind of conservative satire site, remains off of Twitter because they wouldn't recant a post where, after Rachel Levine, who was praised as Woman of the Year by Time, she's transgender, Babylon Bee said, "Oh, we name her Man of the Year," which violates Twitter's pronoun policy, but is obviously political commentary on a high-level military official, which you'd think would be normally allowed. So my question is: imagine that the Republican Party in 2024 has a position to women and transgender politics as part of its platform. And a lot of candidates just sort of say that. They say versions of what this congresswoman said. should Twitter maybe it should just deplatform the Republican Party, because after all, it has a hate speech platform. I mean, it's true, it represents the views of 63%, at least as of now, of the American public, as best we can tell from polls, but hey, it's hate speech contrary to international norms, and we, Twitter, our job is to protect American democracy. So those are my two questions. Those are two hypotheticals. I'd love to hear what people think.
Can I just ask, on if I may, I don't want to jump the queue, but just on this particular point, whether you think that there's any situation in which outright incitement by whatever you might agree would be incitement could lead to a permanent deplatforming, or do you think that that even that would be in part because it's kind of on social media, it's not usually kind of classic, in the context of the the invasion or in the violence, but do you think at least that they could, that on some basis that they could deplatform someone?
I think that's a great question. I think it's a very important question, and I appreciate your point that it doesn't have to be limited to Brandenburg incitement. That Brandenburg may be an interesting guy, but nothing says, at least at this point, nothing says at the federal level that it has to be applied. The reason I bring up the example I bring up is just I would like to know what really people think with regard to not just President Trump, but all sorts of people from all points of the political spectrum. You could equally say about people who want to use violence against abortion, or in favor of abortion rights, or to protect the environment in their view, or to protect animal rights activists. There are lots of groups that have violent agendas. And especially once one shifts from incitement to endorsement of violence, which I take it, probably a lot of us as academics have at times in discussion said, well, I've got to agree, violence sometimes can be justifiable. Some of us are more pacifist, some of us are less. So I think this is a very interesting, important question. I would like to know what the neutral principle is. Maybe people say it shouldn't be neutral, but what the neutral principle as to incitement is, or as to advocacy of violence, that we're prepared to apply to movements that have violent fringes all over the political spectrum. That's what I'm interested in.
I was not prepared to. Interesting, provocative. You avoid Nate's question by.
Well, I don't know the answer.
Right, which and if you start with Jonathan Zittrain's. Look, there are some core principles that we have in mind. So I think it's interesting, but that's not where I was going. So I'm going to avoid that trap for the moment. But pick up on something that Jonathan said with one particular point. I thought Nate's slides were very helpful, but I did think that the prior restraint stuff is crazy.
It's all right, they're not going to do it, but I did want to put it out.
Let's call it pre-clearance.
Right.
Sure.
I can't.
Right. So pre-clearance in this context, I think, just does not seem to make asking with the trillions of possible things that a campaign might put out to then say, right, if the worries are about, if there are worries about the platforms as regulating democracy, well, that sort of takes it on steroids, right? So from my perspective, I think that is very, very difficult to justify, particularly when there are a lot of other possibilities on the table. And yeah, we might worry about a bunch of edge cases, but maybe one place to begin is to slowly think about the cases that are not edge, and that are at the core of I don't know I can't remember the term that Jay-Z used, minimally.
MVD. I wrote it down.
MVD. All right.
Is that right, Jonathan?
Yes, minimum viable decency.
Minimum viable decency. So one could begin there and then figure out how we address Eugene's sets of questions. And I think from a procedural perspective, that provides a place to start, and then to think about what are the edge worries that we have and how far one goes.
All right, so we'll take Genevieve and then Katie F, and then I'm going to turn to the second set of questions because we're a little bit behind, which is totally fine. Genevieve.
I was curious. I mean, this is a response to Jonathan and I think to Mai's remarks, which is the standards that the minimum viable decency standard that you want to apply to the platforms. Does it apply to other speech intermediaries? What's the theory of the liability of platforms versus, say, Fox News or other news media? Do we impose this duty on the platforms because we assume that there is going to be reportage of Trump on other media? Or does Fox News have a similar duty, and it's just that the platform's more responsive, and so we're focusing on the platforms? I'm just curious about people's thoughts. And then second, related, what is the scope of deplatforming? So we know that there's a lot of speech that flows to the platforms that is reproducing Trump's words, but is not in Trump's voice himself. And so it does seem a little, I mean, I can understand the justification, but it seems a very different thing to say we're going to deplatform Trump, but we're going to allow every single one of his millions of followers to pick up whatever news release he's just sent out and tweet it. But we're still deplatforming Trump, or the campaign can tweet it, or Fox News can report on it, and then we're going to link to that story. You could still have a lot of Trump's speech flowing through the platform. And so what do we understand the deplatforming itself to be doing? Now, I take it to be sending an expressive message about our values, especially if we have a minimum viable decency standard. But in terms of getting the message, muting the message, you might imagine also that there will be more coordinated behavior in light of now that there's learning about what happens when Trump is deplatformed, to try and avoid the constraints on the restriction. So what's the scope of it? What do we mean when we say deplatforming?
Let me just say, I think Jay-Z should respond to that, but just as an empirical point, the platforms have different rules as to how secondary content gets. So for example, when Trump does a rally, there are videos of that on YouTube, right? But his channel it can't put these things up. And then Truth Social, and that gets repurposed. There's, I think, particular rules on that.
Well, I guess I was curious about those who think normatively this is what should happen.
Yeah.
What's their vision of the scope?
Jay-Z, do you want to respond to
Yeah,
that?
just a quick thought on that. I do think there might be something to how remote the speech is, how many Matryoshka dolls you go through to get to it, which was why maybe a video of a rally is a little more removed than a direct tweet. Also, it broaches interesting questions around, for instance, Apple taking action in the App Store to ban an entire app like Truth Social or something, or its predecessor, because it doesn't have a sufficient terms of service that in turn bind its users in an enforceable way to certain minimum standards of conduct. And that's 2 levels removed rather than 1 from the kind of interventions we're talking about here. I think that the platforms have a distinct role that they've kind of inhabited, maybe through stumbling into it more than by design. That neutral is always such a tricky word to use, although I think colloquially it's meaningful to people. Certainly there's a certain Texas law that thinks it means something. But maybe I would choose something like transcendent of individual speech and viewpoints, that it's not about viewpoints, and that minimum viable decency can be not about viewpoints. And maybe the hate speech examples that Eugene is raising are different and a concentric circle out from a core. But again, anything that somebody wants to offer up as a difficult or edge case, to me, does not delegitimize the fact that there can be a core that can be articulated and that is or ought to be something shared by everybody on that platform. And the platforms can say, in order to be able to be more or less neutral, these are the basic things that we ask as an ante of everybody coming to the table. And one last thing I want to add, which is I take the question around, well, are there ever forms of condoning violence that somehow might be something a platform under a minimum viable decency standard would want to let through? And I know that, I don't know how much the Facebook folks would want to get into it, but they were confronting that when there were calls from within Ukraine to take action to defend Ukraine against an unprompted invasion by its larger neighbor. And, they're trying to come up with policies that are something like, well, if the calls for violence are against invaders and coming literally from the geographic territory of the country being invaded, will permit them, but not otherwise. Or if somebody talks about making good trouble, those are edge cases. And it may be that the platform would decide, you know what, that is too fine a way to slice it. We don't yet have the mechanism to make those judgments. Incitements to violence, even if in a philosophy class we'd say they are just, would just go take them somewhere else. And that might turn out to be a rule that doesn't have to be as much a standard for administrability purposes.
Katie.
Yeah, just going back to sort of the question of should social media platforms ever have grounds for excluding candidates or political figures, I think that it's important to get away from just thinking about Trump, in part because I don't sense there are a lot of Trump fans in this room. I'm not a Trump fan, but my parents are Trump supporters. And, so I think it's important to think about the issue beyond just him and the sort of lightning rod, but also how does the social media platforms approach to political leaders? What does it mean, nationally and globally? And I think in general, the answer should be that they should err on the side of leaving up the speech of political leaders because of the recognition of the great public interest in the speech of leaders, both for supporters and critics. Because of some slippery slope arguments, which I know people like to criticize, but I always find persuasive in many ways, particularly in First Amendment cases, and thinking about what Eugene is saying, or Shemai mentioned, that there are groups that we might be more sympathetic to, or political leaders who are advocating for either violence or on a more abstract level, or unrest. Let's take to the streets, let's burn it down if it's so unjust, the system. And you can see, again, like what's happening in Iran right now, if you could use the view that you should shut down everybody who's calling for violence, but not in an immediate, this whole idea of immediacy, I think, is important. I think it is appropriate for the social media companies to take a broader view of the kind of speech that could be the grounds for exclusion than the very narrow Brandenburg standard. But I think it's also important that there are lessons to be learned from Brandenburg, which was culminating after decades of allowing prosecutions of anarchists and communists. So I wouldn't throw the baby out with the bathwater on that one. But I personally think that, yes, there are grounds for excluding, but it should be time limited. That it shouldn't just be, you're a bad person, we never want you on this platform again, but rather, did this post violate your content moderation policies? And if so, and if it's something in the area of real world danger, then you keep it suspended for as long as that actual risk persists.
Did you think that the Trump deplatforming on January 6th was close enough to that Brandenburg-like standard?
I mean, I don't think it would have sat if that was a prosecution under.
No, but I'm saying, but you're saying to go somewhat beyond that.
My view is they were justified in suspending his account in the immediate aftermath of January 6th, but that it should not have been an indefinite ban, and that it's, I think, alarming to have, particularly if he announces his, running for president, to have all the social media platforms saying we're not going to allow the speech of one of the major candidates.
Okay, so we're going to transition now to the second question, which is very close to the first, which is the way I phrased it. Are there grounds for excluding or if there are grounds for excluding or deplatforming, what are they? And so we're going to start leading off with Evelyn and then Guy.
Cool. So I think they are very close. And so rather than just sort of repeat a number of things that have been said, which I sympathize with, I think maybe what I might do is try and clarify, I think, some of the things that I think we've been talking about. I think, and people can correct me if I'm wrong, that most people are in consensus that there is a point at which violent incitement in a context where it seems likely would be grounds for some form of deplatforming. I don't think anyone is going to be caught on tape or otherwise in saying no, all violent incitement and certain kinds of very clear attempts to subvert the democratic process should be carried by platforms. I think one of the things that we're discussing is whether platforms should evaluate that piece by piece or as a matter of character. Should they find those pieces of content and take them down? Or is there a point at which someone has posted enough of that kind of material that their entire account has been used? I'm going to use Jay-Z's minimal viable decency as that standard. I think it's a really helpful centering concept for maybe our conversation today. Is there a point at which we stop looking piece by piece? They have entered MVD category and they should be. I think that's the kind of the core of the discussion that I'm hearing. And then I think there's this question of both theoretically, which bucket do we think is right? But then there's also this question of practically, which one is easier to enforce or which one will apply at scale. And I think for a number of the reasons that I put in my paper on both questions, both theoretically and in practice, I think that the content piece by piece standard edges out the MVD standard just. I mean, I see that there's arguments both ways. I think personally that the platforms are playing an MVD policy currently because of obviously they deplatformed him, but also if you look at the posts that Nate put up at the beginning, I think it's hard to say that those were the most egregious things that Trump had ever posted or even potentially actually violated platform policies in those cases. So it was like this, like, oh, we just don't like him anymore. Also, maybe he wasn't so, like, the democratic value of that speech was so low because he was no longer up for election, right? Like, the voters had deplatformed him. That democratic value was very, very low at that point. There was no question about whether this was informing a voter's choice. But I'm concerned about putting that standard into practice because of the scale and global questions. I don't think we've talked about the global aspects of this so far today, but I do think it's a really, really important one. And I think that, for platforms to get legitimacy in their decisions, some sort of consistency is really important. And I think having platforms having a referendum on the character of every candidate in every place is not a practical solution. I think that it is better for platforms to focus on the specific use of their services rather than some sort of global assessment of the character of people, because that will be they will have the expertise, and practically that's an easier way to put into practice. I do acknowledge what Guy was saying about, there's going to be this flood of posts and how do they evaluate every piece of content and things like that. To which I say that's what platforms do all the time. Like, that is in the context of an election, in the context of a conflict, they are evaluating millions of posts, like tens of thousands of posts per minute, as to whether they comply with the community standards. And if anything, it's easier to do some sort of pre-review for a single person or for a smaller group of people who you have already identified as particularly risky or particularly important speakers. And so that's why in my paper, I think like the situations of like complete deplatforming should be extremely, extremely limited. And we should look at these other kinds of practical tools that you can see, like focusing on piece by piece and focusing, like if you know that there's a very high risk that piece by piece there's going to be problems, pre-review I think is a good tool that still preserve the capacity for democratic speech, the public value of having these candidates on the platform while minimizing the risk that we have of extremely dangerous content.
Thanks for that, Guy.
That was very helpful and useful. I will just make three very quick points. One of which is that I think treating particular candidates and categories differently is justifiable. That is, when you have candidates with a significant amount of influence, then the potential for harm is also significant. So paying attention to them, I think, makes a lot of sense. So I'll just assert that, and then if it needs to be defended, I try to do some of it in the paper, but can do so later. The second point is, as among the platforms, the state, and the people, at this moment in time, I'm most worried about the people and worried about the candidates, and worried least, though not that I'm not worried about the platforms. We live in a moment that is extremely polarized, that people are very easily malleable, and political candidates have, especially in this populist moment, they're incentivized to maximize conflict. And so while I think there is reason to be worried about the role of the platforms and the democratic order, so far where we're seeing the biggest threat, at least where I'm seeing the biggest threat in this moment, seems to be more from either the government or the candidates, the people. So we need to think and try to keep the platforms in check, but I would also worry about what we're seeing with the demand side and how politicians are willing to supply it. And Trump is a good example in the American domestic context, but he's not the only one. And then the last point that I would make, I agree that deplatforming um, is an extreme, perhaps an extreme measure, maybe something of a last resort. But I also want to point out that to me, its transparency is an important value, that it allows us to know precisely what is going on. Algorithm manipulation obviously is not as transparent. Partial platforming may not be as transparent. So if you know that the candidate that you're looking for is not on this platform, you know where to get their content. And I think I agree with the statement earlier. So I'd like to, I think there's something to be said about maybe it is a move of the last resort, but there's also something to be said about, from my perspective, that it is transparent to the public, and to the extent that we're worried about the platforms and the way that they might manipulate our information that we want, that level of transparency, I think, is worth exploring.
Before I turn to Nate, let me just ask you about this transparency point for a second in terms of, like, you could have a rule that is transparent, but it requires judgment, right? So when Nate, I think Evelyn just said that, like, those tweets didn't look so bad. Well, they look bad when you have, at the same time, the images of people violently entering into the Capitol. And so you have to take context into account. So I'm wondering, can transparency solve the problem? Or maybe that has to be an after the fact determination?
No, I mean, on the context, in fact, one of the notes that I have here is the importance that context matters. But so I agree with that. But my point goes to the different types of tools, remedies that may be available. So maybe the platforms may be wrong and deplatforming him, but at least we see that, and then we can say that's terrible. We can criticize it for their failure to exercise judgment or for their failure to take context into account. So I think that's the only point I'm trying to make there.
We're supposed to take a break at 10:15, but I think if everyone's okay, we'll go to 10:30 and then take our break then. So we'll hear from Nate, Daphne, and then David.
Can I this might be more of me just provoking Jay-Z and Eugene here a little bit, but part of it is on whether the minimum viable decency standard. I mean, look, obviously that can't be the standard for content moderation, right? I mean, it's like that, and and it's like for two reasons. Both, you can't operationalize it. We all disagree on it, right? But suppose we could come to some agreement on the problem right now. It seems to me, how do you have a minimum viable decency standard when so many people are acting indecently, right? It's not, we're talking about this through the lens of Trump, and we're talking about it through the lens of the insurrection. But I mean, I leaving aside the particular issue that you described in the polls, it's like, you can even go to the insurrection, you can go to the election, you got a third of the American public that thinks the election was rigged, right? It's like, it's sort of the views that Trump holds and the speech that he engages in is not unique in American society right now. And so the problem that's confronting the platforms is that you can't just focus on the speech, right? Because then you're going to be deplatforming. This is sort of, I think, a little bit what Eugene was saying about sort of widely held beliefs and how that could lead to the deplatforming of tens of millions of people. And so I don't actually think it's the indecency of the speech itself. It's the risk, right? It's the risk to democracy, risk to the, to the government, to civil order, and that puts them in, it puts the platforms in a very difficult situation of trying to approximate this. One last thing, and this is on Evelyn's point about whether you go after the person or their content, and I think that's a useful way of thinking about it. The truth is the platforms do both. And so you see this in terrorism context, right? So that there's certain types of people based on offline behavior who will end up being deplatformed. And so that their advocacy, right, is kind of put into a different box. And part of the question here is that appropriate to a political leader? Is it appropriate to the context here with Trump? Since I've provoked, I want, people had their tents up and wanted to do that, but I don't know if Jay-Z or since their names were invoked, as they say in presidential debates, if either of you want to respond to that.
Jay-Z has his hand up.
Yeah, thanks. Yeah, so as the coiner of MVD, I think it's meant to be an ethical lodestar and font more than it is to be like, and here's our standard, like see mvd.org. it's basically to prevent platforms and people who want to do the right thing, which is something independent of whatever they think personally winning means, that actually acknowledge there exists something called ethical that might differ from their own interest at any given moment. It's a way of saying, don't abdicate from acting or taking up a choice because of a well-meaning but misplaced ethical sense that if you get into this, you will only and always be in a hall of mirrors. You will only end up being biased. You just need to do nothing. That's, to me, the function of trying to coin an idea of a minimum viable decency that then has to be spelled out a little bit with something, for example, having to do incitement to physical violence. And I think, Nate, it's all the more important to do when the problem is all over the place. It makes it harder, but that's when there's the imperative, not when it's in theory and kind of costless to say the Nazis are marching in Skokie, but it's kind of nobody cares. All right, great. How do we handle that? And if anything, it's a reason, in answering Rick's second question, I think it's his second, to single out candidates and officials in high office having a tighter standard. They have special power. They are or are about to be, if they win, committed to special responsibilities. And it's saying, we're going to hold you to those responsibilities for the small piece of turf that we have some choice about, and we'll be clear about it, and et cetera, and we're sorry it's come to this. But if you circumscribe it to the candidates and officials who already have megaphones in lots of other places, to me, that's exactly where, for symbolic and demonstrative purposes, but also for functional ones, given the power of those candidates, where it makes sense to intervene.
Percent of the Republican conference in the House believes the election was rigged, and that
But Nate, I don't think that matters.
well, that's my question. Does it matter?
But I want to keep. I've got 7 people who want to.
Yeah. Sorry. So anyway, I was just wanting to see whether that would fail the minimum viable decency standard, that you'd end up with 70% of the Republicans in the House ending up being deplatformed by one of the platforms. Anyway,
I'll pass so this can continue.
Eugene, go ahead. No,
If I could
get to you.
just briefly respond to Nate's point. Look, there are lots of people who think any opposition to transgender rights, including having people who are born male, let's say, and I realize even that is a controversial way of putting it, are entitled to participate in women's sports so long as they identify as female. There are many people who think that is below the standards of minimum decency. They think it is indecent. They think it is hate speech. In fact, Twitter thinks it's hate speech. We know this because that's how Twitter acts. Now, there, of course, are other people who think that it's indecent, including people who style themselves women's rights advocates, I think quite sincerely, that it's indecent and a violation of women's rights to require them to compete against people who physically were born male and have these advantages of having male bodily development. And then there are a variety of other such situations as well. So I would just like to know, I appreciate these are edge cases, but I would like to know on behalf of, I'm not a Trump voter either, but I do know people who are, and I know people who take the indecent views of a wide variety of such subjects, whether it's indecent views on abortion or indecent views on affirmative action or whatever else. I would like to know what's going to happen to us. I would like to know whether really the plan is to exclude our views and the views of candidates we want to support in close elections where the exclusion might matter, to exclude us from these platforms, because that might make a decision for us. The one thing I want to avoid is buying a pig in a poke. I wouldn't like to see, again, people like me that I care about be in a position where they're sort of told, oh, no, just minimum viable decency, just incitement to violence. Oh, but it's also after the fact glorification of violence. And it's just hate speech. Who can be in favor of hate speech? But it's also opposition to transgender athletes in women's sports, and it's opposition to abortion, to anti-abortion views, because anti-abortion views are hate speech against women and such. It just would be nice if we had a sense of just how much we'd be excluded from these things.
Well spoken by the author of the article on slippery slopes.
Oh yeah.
So we've got Daphne and David, and then we've got Eli, Renee, and Chinmayi, and it's starting to sound like a faculty meeting. But
so my point was in response to Evelyn and somewhat to Guy, And usually I agree with Evelyn, so this is very exciting. I get to disagree about the idea
Usually
that
Daphne's right. So I'm scared.
just as a practical matter about the idea that platforms are doing adjudications like this, tens of thousands of times a day, which they kind of are, except that those adjudications are much lower stakes and they are executed much more sloppily, and the consequences of being sloppy are pretty low, whereas adjudicating a tweet by President Trump is extremely high stakes, and they would presumably bring a level of care to it that they could never possibly bring to all the other similar tweets coming along. And then this kind of goes to your point about transparency. Like, what does it mean to be transparent about each of those decisions? Are they issuing like the equivalent of a court ruling explaining the response to each of the tweets? That is, again, something maybe you could do as one-off treatment for the president, ex-president of the United States, but like you can't do that all the time. So I think it's unavoidably this very special casing.
You know that Musk responded personally to Kanye West,
Yeah.
so
Very
he could just
scalable.
go out and moderate content.
There are
whenever
two
he
people who got
wants.
this.
David.
So I guess, there's a risk in what I'm going to say is going to cut into our next session.
That's okay.
So I'm sort of figuring that part out. I guess the thing that's confusing me a little bit about this discussion is there's a way in which I feel like we're doing interior decoration before we've designed the house. And I guess MVD, Jonathan's sort of standard, gets us to that point, or at least moves us in the direction of designing the house, of designing the standards. But I feel like we really need to start with standards. Like, what are the bases for making any of these decisions, and where do we draw them out from? And I haven't really felt a good answer as to what are we sourcing all this on? Or is it just sort of our idea as to what it means to protect democracy or to protect others? So my intervention here is really just to push us to sort of figure that out. And I wanted to go back to Nate, something you said in the very outset, which where you were asking, in effect, should there be different standards across platforms? I actually think you can have different outcomes across platforms, but the standards can still be the same. Whether it's MVD or, as I would argue, as Evelyn knows, or others here, although I had a traumatic experience presenting this at the Hoover Institution like 5 years ago. But the idea that human rights standards actually provide the right standards, and in a way that companies are already doing that. I just want to make sure that when I leave today, I have a sense of what's the basis for the decisions we're making, or our views, because ultimately the companies are just going to make the decisions. So far, although, and this is something I'll say a little more about later, we should be mindful of the fact that the European Union is moving way beyond this conversation toward transparency and risk assessment and all that. And the Facebook Oversight Board is doing some of that already. So, maybe at some point we can move back. Maybe it's articulating more what MVD means. Maybe it's articulating what human rights standards mean. But those, I think, provide us a way to think through each of these individual questions.
Okay, so we'll take Eli, then we're going to take a 10-minute break, and then we're going to pick up with Renee, Chinmay, and Evelyn's put your cart up and down and up and down, so I'm going to add you to the list.
I don't know if Chinmay also wants to get on this session before the break here.
Are you being generous and offering?
Why don't I try to tee you up if that's okay?
Thank you.
So a couple quick comments. One, just to sort of invoke you and Evelyn on sort of how to think about a global standard to analyze this issue and getting away from Brandenburg and the First Amendment. And you'll see, obviously, in the Facebook Oversight Board decision, there is sort of like a tip of the hat to First Amendment jurisprudence and its importance, but also just like it is not a standard that most other countries are familiar with or even close to when it comes to how they think about these issues. And so I think that the Rabat framework that's used in the decision that's been discussed here actually gets at a lot of the issues that folks have talked about, whether it's the context, off-platform, on the ground, or otherwise, the status of the speaker, their reach, all of those things are explicitly delineated in Rabat, and I think very useful to think about the different kinds of politicians and speakers and how to treat them differently. Second is, this is not the first time Facebook has had to think about when politicians perhaps cross over to be dangerous individuals or organizations in the context of a political party. I would just encourage us to think about past instances where Facebook has had to contend with that. And if you look at the leaked dangerous individuals and organizations list, which Facebook maintains, which is not public, has some names on there, and
So
there may
if we look at it, but it's not public?
Well, it was
it's now in the
leaked.
public
It was
domain,
not
it was leaked, it was
officially
not
made
official,
public.
but just to be clear, the oversight board did not leak it. Other people did. But I think it's interesting, right? Because like there are other instances where you have to deal with. I mean, Hezbollah, I think, is perhaps this has happened in other democracies, right? I think is the point I'm trying to make, and it was messy then. There's been litigation that Facebook has faced, and so that has informed the way they behave. And then the last thing is transparency, to invoke Guy, I think is critical. And really the only reason I would argue that there's a detailed explanation of why Facebook did what it did in this case is because it had to respond to the oversight board. And that is cited at length, Facebook's reasoning is in the oversight board decision. Absent that part of the process, I don't think there would have been as transparent an accounting of on what basis, why, and all the steps Facebook took in reaching the determination it did. But that does not scale. I mean, Daphne's absolutely right. I mean, like, Trump is the special case of the special case of the special case of the special case, and the teams that Katie helped create that exist for high-profile elections, I would imagine exist to deal with Brazil right now, the U.S. and other major elections. Like, they have those teams in place, but what is the bandwidth and what's the throughput they can handle, and what does that mean in terms of how you treat certain elections in countries differently than others? And that's a real challenge. So we'll stop there.
We're going to continue this discussion, but we're going to continue it at 10:40, so everyone could just have a quick coffee break. But I think the mics will still be on, so anything you say at the table and will be held against you.
Yeah. So
We've got Chinmay still on there, and then we're going to turn to the next set of questions. Go ahead.
Thank you. Clearly not loud enough. Eli did tee up what I wanted to say magnificently, so thank you for that, Eli. I wanted to clarify a couple of things which I think are relevant to the conversation that the last panel had. One was that when I said that there are questions that are difficult to decide, I didn't mean that we should do nothing. I meant that we should expand outwards. And so if we have great ways, for example, of thinking about anti-Semitic speech, then there's good reason to start thinking about speech, racist speech and speech targeting refugees in similar ways. And I think that we should learn from it and expand outwards was my point. The second, which Eli set up, and it's a question that David asked about what are the standards, is that in addition to the Rabat Plan of Action, David's reports, and the Oversight Board's wonderful decision, sociologists, every time they write about hate speech, and I know because I sometimes write about hate speech too, always come back to the question of the role of leaders and their validation of violence. It doesn't even have to be actual incitement to violence. And I think that there is a case to be made for leaders like Donald Trump and their likely effect, even at a point at which their words are not actually inciting violence. The loop has been created. And I think, well, I feel like most of you wouldn't agree, but I think that platforms, the big ones, have the capacity and a duty to find experts who are able to create norms for the societies that we want to live in. And that in part is an answer to Genevieve's question. And I feel like the Oversight Board is actually a very good step towards that, even if it's not strictly democratic. People's quarrel with it is that it is elite, but it's also people that study democracy and are trying to distill its ideals in particular ways. And I feel like that's sort of an elevated and complicated minimum viable decency. It's sort of expanded. And if people didn't like that, then I assume that they would be hanging out more in 4chan, but they are on the major platforms. Stuff.
All right, Nate. Great, thanks. So the next question is, what are the benefits and risks of those decisions being made by private platforms? So I think we'll, as with the previous questions, we'll probably expand beyond that. One thing I just want to finish, tie a bow and one of the points I was trying to make before, but I think it bears on this question, which is that I kind of feel maybe this group doesn't appreciate how popular Donald Trump is, and how popular his incitement is, and how popular some of this other kinds of speech is. And so the question, it seems for me, and this goes to the platform power question, is under a condition where what we see as dangerous speech that might actually lead to the decline of American democracy is actually supported by a huge amount of the population, what should the platforms be doing? And that's why I was mentioning, the share of the Republican conference in the House that supports this stuff, because are we actually going to say that the platforms are going to go after a significant share of one political party? With that indulgence, let me turn to David and Renee.
All right. I'm going to pull this over because my voice is a little out. So we are talking about what are the benefits and risks of these decisions being made by private platforms. And I wrote some things down, so I'm just going to read them. The primary risk of policy decisions being made by private platforms in this case is that the platforms are private power operating in service to particular incentives, and the incentives of the business are not always aligned with the incentives of society overall. We haven't talked about design much in this workshop, but for example, recommender systems create ties between individuals, nudge them into community structures. These are the kinds of participatory environments that lead to a lot of time on site. The overwhelming majority are innocuous, but some of the groups become radicalized. Members begin to engage in online harassment and allude to offline violence. It falls to the platforms to understand the dynamics of these communities, to discern which violate terms of service, and then to decide whether they can stay on site. And this is all done with no transparency. The public must hope that the decision-making process prioritizes the public good rather than solely the business case. There is often little to do beyond hope, as users have little leverage, particularly outside of the United States. Additionally, for those who are actioned and fall into some of these mass moderation decisions, particularly wrongly, there's often very little recourse, so there is an individual impact there. But the individual impact of moderation calls has also been rather opportunistically exploited by another power, politicians. So platform policies influence the propagation of messages, not only within their own sites, but across the entire ecosystem, and often subsequently to broadcast media environments as well. The capacity for determining whose messages will reach the public is a significant power, increasingly key to shaping public opinion and amassing influence. This means that the platforms themselves have become pawns in power games. Where once ref working, which is trying to make platform policies preferentially favorable to one's own side, took the form of powerful politicians and media figures engaging in private conclaves with platform executives, the new model has actually become public attacks that attempt to delegitimize moderation, even in its most mild forms, such as labeling, as a partisan act, as viewpoint-based censorship in populist appeals to the entirety of the public, to the support of their base. The risk then is that although platforms retain their capacity to curate their space via moderation, they are subject to pressure by powerful political forces who could theoretically wield regulatory sticks in retaliatory ways. So as moderation itself has become perceived with censorship among a growing segment of the public, as it's been seen as synonymous now, platforms are aware that this strategy, the negative impacts of the perception by the base, potentially leads to declining public opinion of their brand, distrust in their products, or users migrating to other platforms, which reduces time on site, which is also then bad for business. Legitimacy matters to the platforms, and now moderation itself poses a risk to their business, which may alter their moderation behavior in response to these pressures, leading again to negative impacts to users and society as that ref working takes the form of shaping policy decisions around powerful figures. Outside of the US, we see this also platforms being subject to capture by governments writ large, by governments that are in power that want to maintain their power, requiring that platforms take certain moderation decisions that are favorable to existing regimes. So that's risks. I think the benefits answer also really touches on design, which is that there is nobody else who can make these decisions now, right? There is no other infrastructure for making these decisions. Very few people have the data, the capacity to understand the decisions. The platforms do. The tools are theirs, and they can act quickly and decisively. And that, I think, is the primary benefit. When a world leader is tacitly inciting violence, they can examine the propagation response and the responses by the followers in the closed spaces. They can look at the dynamics of that message propagation and try to gauge whether that is or is not likely to lead to real-world violence. So there is an extensive amount of data and analysis that a platform can do to assess whether speech is being received in a theoretical sense or more in an incitement sense by understanding the data that they have around the dynamics of the audience that follows the speech. And then they can decide whether to cut off the megaphone and reduce the propagation. So that, I think, is the kind of risks and benefits in this space.
Great. So, so I'll first answer the question, sort of. It's always sort of, and then make 5.
That's always helpful to actually answer that.
Right. And then I'll make 5 claims that just because I have your attention, make them. I don't know if they're responsive to the question.
That's good.
So actually, Renee said a lot, although a lot more eloquently than I would, about risks and benefits. And let me just say a couple of things about risks and benefits before making my 5 kind of claims. So one is the risk of platform the sort of platform power. I mean, the things we're already talking about, right? Applying a business interest over a public interest, which seems to be a key one because we're talking generally, I think, about the public interest, and they don't have a responsibility toward that. So that's a risk. There's a real risk. I think Chinmay highlighted this of jurisdictional preferencing or jurisdictional ignoring, right? In the sense of, the center versus the periphery. It's easier to make rules around the center than around the periphery, but actually in the periphery, and I'm using that advisedly, is a place where the most violence actually takes place. The periphery, by the way, could also be in our own domestic communities. It doesn't necessarily have to be a domestic versus international. The advantages, I think, start with the fact that I don't want the state to be making content decisions. And as you look around the world and you see what happens when the state makes these decisions, they're almost always, moving towards the problematic. And, whether it's authoritarian decision making or it's, all the lawful but awful stuff that Daphne has written about, there's huge risks in giving that power to the state. Okay, so then I want to make 5 quick points. So one is
those weren't your 5 points.
No, those aren't my 5. So these are, but that was 5 almost. Well, so one is I don't have to say much about any of these, but one is they will make the decisions, as Renee said. I mean, they are making the decisions, but of course, we're framing this as social media. It's not just social media. Kiwi Farms, just within the last few months really highlighted that other players in the stack are perhaps even something that we should be more concerned about in some ways. Second, the companies do have responsibilities, not necessarily legal ones, but then again, I want to pull us back towards human rights standards and say under the UN's guiding principles on business and human rights, there's a framework for us to understand how do companies implicate human rights generally, and what are the standards they should adopt to either prevent or mitigate those harms. So there is a standard out there. I actually think the companies have moved towards understanding the UN guiding principles in pretty interesting ways, not necessarily implementing them, but that's something to be accounting for. Third, they need standards. I already made this point. I don't think the standards, even if there's a common standard across platforms, across companies, across the stack, it doesn't mean that it's the same outcome on every platform or with every company. Fourth, human rights provides the baseline standards. I mean, we could have a whole conference just on, maybe I'll organize that one in sunny Southern California for that one, but I think they are effective and there's a lot there. And you see it in, I mean, whatever you think of the oversight board is actually showing how you can articulate, review these standards almost like a court would, right? And then the last thing is just to say, regulation is already here. I mean, the Digital Services Act was already adopted in the European Union. If we ignore the Brussels effect, we do it at our peril because the companies are not going to ignore it, because obviously economy of scale makes sense. And so transparency matched up with risk assessment are going to be public rules for all of the companies. And so there's a way in which our whole discussion is sort of in the shadow of that, even though we're not having that discussion, but we should be mindful of that being a sort of overhanging issue for us.
Great, thanks. Can I just ask you a question? Which is a version of the same question I probably asked you 7 times before, but in this context, which is, all right, so you know more about international law than I'll ever know. What we saw the Rabat framework that was in the oversight board. How does international law answer this question as to whether he should be returned to the platform now?
Right. So it's sort of what is my view in a way of.
Oh, you're interpreting. I mean, like you know this better than I. So if there's an answer that's provided by international law here, I'd be eager to know.
Yeah, but it's the reason why it's hard to answer that is the point that you made at the very beginning, which is there's variation across platforms.
Yeah.
So it's very hard to answer the question in the abstract.
So say
right?
Twitter now.
Right. So Twitter now, I would look to the standards and basically say, looking at, is it necessary and proportionate for the platform to restrict, to limit Trump's access, given the need to protect the rights of others, which is incitement, and then using the Rabat principles, I would say, yes, they are justified to make that decision. But I also want to, so I'd say that's where international law would lead me. But I also don't think there is necessarily a right or wrong answer. What I want is for the companies to adopt a standard, to transparently evaluate how they're applying that standard, tell us what it is, and then we can debate about it. But that sort of gets us toward having the discussion in a way that makes more sense to me. But I do think the answer is they're totally justified in.
No, that would be true for each one of the platforms, don't you think? That wouldn't you come out the same way?
It might even be, more justifiable. So, for example, I mean, Renee and the Internet Observatory have done, studies of the interactions among accounts. So we're thinking of this at one level as just sort of like this one speaker and their impact on society. But there's a lot going on under the surface that I don't have access to that involves sort of the coordination of accounts, the manipulation of algorithms, all of that stuff that's happening that the platforms might even have stronger reasons to ban a particular account that goes beyond the mere content. And our focus on specific content might actually move us away from thinking more, I hate to use the word, holistically about sort of the interaction and the impact of the platforms on society.
I just to follow up with David, do you think that the indefinite bans are justified under those human rights frameworks?
I mean, I like actually the way the oversight board came out on it, which is evaluate it again, right? And that's so like regular evaluation, but that gets into the implementation of the particular standard and the proportionality of the restriction. And if you build into it, sort of repeated possibility, that sort of ongoing impact assessment, I think that's better than just saying this is for life.
I mean, one of the things I've been thinking about is sort of an analogy to the law on public forums. So generally, if there is a public forum that's open to members of the public to speak, you could impose certain use limits on it, and you have to, obey the sort of time, place, manner, et cetera, limits. But if you say something that's outside of those limits, you can be told to sit down. But when you are transposing the public forum in social media, you have a lot of governments, actors blocking people forever. So you're effectively telling them they can never speak in that public forum. That's different. That's a government-run social media account. But to me, there is an analogy here of, if you violate speech norms as imposed by social media companies, when and does that ever justify a permanent ban, as opposed to looking on it a content by content basis, and with an assessment of the context and real world impact.
Yeah. Well, I've got something to say on that, but Rick, why don't you jump in?
No, so I want to ask both David and Renee, in thinking about like what that private platforms have this discretion and they don't all have to do it the same way. But of course, Twitter and Facebook decide within hours of each other to get rid of Trump at this traumatic moment. So, I mean, I don't, maybe Eugene would not agree, but I think everyone else would agree that a major candidate advocating violence, whether Trump did that or not, would be a basis for exclusion. What about a candidate who never advocates violence, but who consistently denigrates the election system, which is my main concern, and says, it's rigged, it's stolen, and convinces millions of people that you can't trust the election results, which could cause the deterioration of democracy? Is that a kind of standard that either human rights law or otherwise is something that is implementable and should be implemented?
Well, I mean, yes. I mean, you could. So it's hard. I think that transparently the companies need to spell out what the rule is. But so, under human rights law, under Article 9, is very basic, but under Article 19 of the International Covenant on Civil and Political Rights, which the U.S. is a party to and like 170 states are a party to, the state can, and we're doing this by analogy, obviously, but the state can restrict expression so long as it meets tests of legality, necessity / proportionality, and legitimacy. So one thing is, and again, the Oversight Board spelled this out, you need to have clear rules and communicate them to your audience, but you also have to figure out what's within that legitimacy frame. So it actually specifies the rights or reputations of others, national security or public order, public health or morals. So you could imagine coming up with an argument that, that kind of intensive speech, which is obviously tied also to other things related to violence and incitement, is an interference with the with public order, and public order isn't really only understood as like riots in the street, but is also a public policy justification. It's hard for companies to do that because companies don't have, as I think has been mentioned, they don't have the democratic grounding to decide, what's in, what's in sort of in keeping with public order, public policy. But I think there's ways to do that. We just haven't articulated that very well. But that's sort of the path that we would need to be on.
I think can I just add the one point? I'm not a human rights lawyer, I think, but as we look at, again, design, moderation is not binary. And we're treating it as if it is a censorship or free reign, and that's not the case. And so what we've seen with remove, reduce, inform and other platform moderation tools is that there's a fairly big bucket of areas and of ways to enforce, if you will, on those types of concerns. I think, again, one of the challenges is that platforms have the best understanding of the impacts of that speech. And those of us on the outside can see this is going viral. Here's how it propagated. Here's who moved it. Here's the influencer that drove it. Here's how the crowd appears to have responded. But we do not have visibility into what all of those people then go and do. So it's not the hypodermic model needle of somebody saw the communication and immediately was converted. It's more that question of how does that persuasion happen over time? This is where, again, not to beat the drum on design, but there are different ways that people engage with content on a broadcast platform like Twitter, where they see it and it's fleeting and it goes by. And you can look at things like labeling or reducing distribution of false or misleading claims, or something like Facebook, where they're going to have a discussion about it and they're going to reinforce each other's points of view, or any other platform that has more of a closed crowd model of deliberation among the people to come to a formation of an opinion. And so looking at ways in which we've understood censorship to be actually to have sort of a blowback effect of the forbidden knowledge, and in some ways, actually, I think the takedowns are the worst possible intervention on content like that.
I want to turn to Eugene, but I want to also do a delayed or a belated hat tip, which is that in my original presentation, but I meant to cite Renee and Evelyn for two propositions. Renee for the idea that freedom of speech doesn't equal freedom of reach, and so that which picks up on what she said here about how you might reduce the amplification, and Evelyn for her work on content cartels, that maybe there would be different rules for different platforms. So now I've done my citation duty. Let me turn it over to Eugene.
So I want to piggyback on Rick's question, which I think is an important question. Since 1790s, American law has dealt with the question of to what extent are statements that essentially alleged lies. This is Sedition Act of 1798. Alleged lies about the government undermine democracy by breaking the bonds of trust between people and government and such. So let me ask this. Let's say that somebody is routinely saying, including perhaps some things that people might view as false, or at least opinions that are highly misleading or highly selective. Not that the election is rigged, but that the police are rigged and that the courts are rigged. And it could be either they're all corrupt, they're all in the pay of whoever, or they're all racist, or they're all religiously bigoted, or all the bigoted against conservatives or against liberals, or whatever else. I mean, I take it that could also quite sharply undermine trust in democracy. Elections are a tremendously important democratic institution, but so are courts, so is law enforcement. So I'd like to ask, what about that? Let's say a platform said, we think there's real danger to democracy from people undermining the important work that these entities do. So especially if we think that it falls in the category of dis or misinformation with regard to the honesty or the equal treatment offered by courts and the police, we're going to suppress that. And speaking of international norms, my understanding is that some countries do indeed prohibit certain kinds of criticism of courts as essentially contempt of court. It used to be so in America until around 1962, I think was the case that would be Georgia that most clearly put the nail in that bucket. It was a debate that actually went on from the early 1800s on in America. But I take it under international norms, I don't know. So just, I want to ask, what your reaction would be with combination of Rick's hypothetical and that.
So I would say to that, again, the counter speech and contextualization by way of labeling and potentially risk reduction addresses those same concerns. What you're talking about is delegitimization, right? Just kind of wholesale delegitimization. What I would argue, we try to think about our work and like why we look at elections in particular as kind of high harm, high impact because of the potential for impacting a transfer of power. Because an election has a state of the world before and a state of the world after. And so there's this kind of pivotal moment where it's not just a shaping of perception or a persuasion of the opinion of the public over time, so much as there is going to be an outcome here. And so as both sides have kind of like a heated battle over that moment, the questions around delegitimization of elections, primarily, in my opinion, the harm is the perception that the government is illegitimate following the transfer of power, leading to a higher likelihood of violence, a higher potential for the kind of revolutionary rhetoric that we see. So I think we treat elections as being a particular transition point that's slightly different and requires perhaps a higher standard of observation and analysis than something that is just arguments against the legitimacy of institutions in a country over time.
Rick, do you want to respond to Eugene also as to whether you like other anti-regime violence or anti-regime illegitimate speech akin to questioning democratic results?
Yeah, I mean,
and then go to Katie.
And
then Guy, sorry.
I think that there's candidates and major political figures have a special responsibility, and I would say platforms similarly have a special responsibility to not either engage in speech that is likely to incite violence or engage in speech that is likely to cause the end of democratic institutions like elections, which assure that everything else is possible. That the platforms as private entities can decide to be responsible corporate citizens, just like I would urge those businesses that make donations to candidates not to donate to candidates who support the lie that the last election was stolen, not as a matter of government fiat, but as a matter of being a good corporate citizen. I would say the same thing about these platforms. These platforms are not operating in a vacuum. If people want to get that content, they can get it on Truth Social, they can get it on Newsmax, they can get the content, but you don't have to be a conspirator with those who are trying to overthrow or undermine the government. And I think that that's uniquely different than kind of random social violence. I think we talked about this months ago, Eugene. I don't think that Black Lives Matter protests, for example, threatened to bring down the government in the way, even though they led to occasional violence, in the way that storming of the Capitol when Congress is counting the Electoral College votes caused that. And it's appropriate for responsible companies to make a differentiation there.
Katie, I have is next. I saw Jonathan put up his hand. Was it on this point or?
And Marianne.
Marianne. Oh, is Marianne also?
Oh, no, it's Jonathan.
Katie, do you want to jump in on this point, or should I ask Jay-Z?
If Jay-Z wants to.
Jonathan.
Yeah, just a quick thought to address Rick's question. For what it's worth, in our minimum viable decency framework, I might be tempted actually to put challenging the results of an election outside of that. That is to say, it wouldn't be part of that. It's the kind of thing that would require probably judging the merits of the claim in a way that I think judging incitement to violence doesn't require you to judge the justness of the cause for which you are inciting violence. And if you're having a look at Stacey Abrams' claims about a prior gubernatorial race, as well as Trump's claims, let the other elements of the system do their autoimmune function, the litigation, Rule 11, sanctioning the lawyers involved, that sort of thing is my temptation, because I do start to worry about enforceability, interpretability, slippery slopes, that kind of thing, even as I see the existential crisis caused by discrediting the entire system.
You want
on this point, yeah. So I completely agree with Jay-Z. I think I would add one additional consideration, which is there is the underlying subtext of what I understand to be, I shouldn't ascribe this to you, Eugene, but someone might believe, which is that the platforms are putting their thumb on the scale. And so to the extent then that we have a series of these types of judgments that are being made, that worry becomes magnified. So I definitely would put violence, and then however incitement, immediate, et cetera. But we could have an argument about that. I might then include something about ethnicity. Maybe we could have a debate about that, but I would definitely put elections, misinformation on the other side of the scale, and use Renee's remedy of counter speech for those purposes, precisely to worry about the worry that other people might have that platforms are putting their thumb too heavily on one side versus the other, which I think is important.
I just want to follow up question.
I don't have anything else to say.
Okay. Counter speech is one thing, but I heard Renee saying also like demotion of material. So, you know,
in labels,
labeling, but to demotion of material. So take the Hunter Biden laptop example. I think that was a total overreaction on the part of the companies in excluding the stuff. Isn't that, you know, that's got to be in the toolbox, and that's going to be criticized just as much as being political as cutting out the content completely.
So I just had a two-finger intervention.
You want to jump quick?
You need to go ahead, David.
No, I'll just, I mean, I only want to say what Jonathan and Guy said was, I think, consistent with how human rights standards would actually approach this question, and which is useful, but you know, we'd have to think through that. But also the second part of what is the remedy still requires you to make a decision as to the content itself. So it doesn't immunize us from making that initial call as to whether it's legit or not.
Take as much time as you want, Katie.
I know, I don't have that much time. 2 points I wanted to make. One, as we're having this conversation, and we were talking about this during the break, you can have transparency, you can have quality, you can have speed. You can't have all three at once. Yeah. And so I think what Renee was saying with some of these intermediate things and some of the questions that we were talking about here, you can also have those at different parts of the conversation when we're talking about this that's worth thinking about, because there were many times there were things where we're like, that seems really bad, but we don't have a policy to point to for that. So do we take it down and justify it later, which will come with criticism? Do we leave it up while we try to figure out a policy that we can be transparent about so people know they're breaking the rules, but then it stays up and then there's harm to that? And so you definitely need some of those, I think, intermediate areas in which to do that, to then have the deliberation around trying to decide exactly how you handle it. But it's really hard to do all three when you're getting it from all different sides of like, we want all those things, and I think we would love to have that. It's just not reality. Second thing is, David, to your point about it not just being content, you know, I think Camille Francois originally coined the actor behavior content model. And so there is a behavioral model we haven't talked about that is mainly used around foreign interference with the coordinated and authentic behavior. When you start to apply that domestically, you start to get in some really tricky questions of what is considered legitimate campaigning versus what is potentially an authentic coordination or coordination we wouldn't want. When you look at just the behavior is really hard. So yes, trying to come up with systems to be able to look across those contexts, I think, are things that platforms are wanting to do. It's just really hard to do at scale, which I'm trying not to say over and over again during these conversations. But those are the 2 main points I want to make.
One thing I'll just add that, you know, the platforms, this goes and as a transition to Evelyn and then Eli, is that the platforms have different rules on election denialism, right? So that you have, YouTube has taken a very hard line on this, actually taking down videos that allege election denialism, and then the others have mainly labeled and demoted. And same thing with Hunter Biden's laptop, by the way. Facebook kept it, as I understand it, you were there, right? They kept it up, they just didn't amplify, right?
Correct.
Is how they dealt with that. Evelyn.
And after Evelyn and Eli, we'll transition to the next, the fourth set of questions.
Cool. So maybe just 3 points on anti-democratic speech. I think I would be more nuanced on that question as well, because I mean, if your justification for giving political candidates a bigger platform than others is democratic self-governance, which it is for me, then there is this question of like at some point speech stops serving democratic self-governance. I think delegitimization is a trickier question. I would agree with a lot of things that are said, which is often it is very important democratic speech to talk about the processes of an election. But things like saying wrong polling booths or dates or like stuff that undermines, like that messes with the channels of political change and democratic processes in advance to allow voters to express their will, I think is a category that would fit for me in like justifying censorship of those views. On speed, transparency standards, I think that's so important. And I think that really what I would have wanted to see was platforms tie themselves to the mast much more in advance in the run up to the election. And I wish in part this conversation wasn't having to happen now, because there was this moment post the Trump deplatforming where we thought we would develop a lot of these standards in advance for the next election, and here we are these years later and it hasn't happened. Twitter announced a public consultation about developing these standards, and we never heard about it ever again. The oversight board sort of developed a very loose framework, in my opinion, that didn't really give us a lot of content to how that these decisions would be made this time around. YouTube, I can't even. So let's just leave that one on the table. So I wish there was more discussion about like what the standards actually were, because if so much of this is like platforms putting their thumb on the scale in a politically illegitimate manner, some of that can be countered by having clear standards to point to in advance. Now, obviously, they will never be able to get away from bad faith attacks on their political motives, but some of it to the people who are, good faith participants in this debate can be aided by that. And so, now, yesterday was the best time. Now is the second best time for developing those standards in advance of the election. One of the things I'm reminded of is like Twitter announced and other platforms announced really clear standards of who they would defer to for deciding when a race had been called. So on the night of the election, they said, these are the outlets, 6 outlets or whatever, that we will judge if a race has been called, and anyone that announces that they have won an election in that state before that has been called by those, we will take it, we will label it or whatever it was. I think that was fantastic because it said we are like we've tied ourselves to this mast. It made it really clear that it was not a political judgment. And then you saw things like the Team Trump account changing the way that they announce like the results of certain things, like citing the part of some of those sources to say we have won ABC, whatever it was, like which I think was really interesting. So this like having standards in advance can shape behavior down the track, and like behavior is not static. Behavior responds to standards and incentives as well, and I think that that's something that it is potentially missed. I have more to say on like actor moderation, but I'll leave that maybe for later.
Can I ask you a question though on this, which is on incitement?
Mm-hmm.
How much more specific could a standard be? It's one of these things. Certainly not in advance. They're not going to say, well, if they're actually at the window of the Capitol, right? Then there's one standard that kicks in. I mean, it's like when you look at something like Brandon. Again, we're using the First Amendment just as analogies because they deal with these kind of courts deal with these kind of situations. Like I don't even know how I would rewrite these platforms incitement standards, frankly, to make it more specific about what some when something gets triggered, because you're dealing with this kind of whole panoply of human experience here.
Yeah, so I agree. Like at the end, there's an irreducible amount of discretion. However, I think there could be more articulation of the things that they will look at. So are we looking at on-platform versus off-platform? Mm-hmm. Are we looking at what the candidate has said on Twitter, or are we looking at what they have said at a rally? Are we looking at like what are we looking at announcements by accredited law enforcement about what's going on? Like I think listing a bunch of like evidence things that they will use to consider the factors that we put out in advance that can't be entirely specific, I think would be really helpful, because then they say, look, the FBI has issued a notice that something, or there is a state of emergency in Washington, D.C. at the moment, and that is our relevant consideration. That then becomes depoliticized in a meaningful way, I think.
Well, whether it gets depoliticized, so suppose they say if the Department of Justice says, or the January 6th committee, and I'm not trying to be the typical law professor here. Part of it is, as you can see, I keep returning to the fact that that everything the platforms are going to be doing here is going to be seen as pro-Biden, and so anyway, Eli.
So right. So to pick off where Evelyn was answering your question, I think that's right. I think a lot of people criticize Facebook somewhat rightly, but also like Facebook does deserve credit for having generally much more detailed policies than any other platform. So I just want to give them a plug. On the other side, it's nearly impossible to actually understand how the content enforcement system works because you don't have a unified source for where all the rules are and then what happens when you transgress them in certain ways and how that builds up an escalatory sort of pyramid to ultimately being banned. And that's something that keeps getting called out by the oversight board is, well, if you engage in this kind of violation, we have this kind of scalpel. And if you engage in that kind of violation, there's this kind of medical instrument. And then, but then there's a newsworthiness exception. If you're a political candidate, we lean into that. And it ends up being a really hard decision tree to frankly track. It's actually next to impossible to actually sort of map that out. And so I do think that goes to undermining legitimacy because you can be transparent up to a point, but when the transparency is like, well, there are these 18 different things you could go off, and it's like, how the hell do I make sense of that system? And I think that you're seeing improvement and evolution of it. But I think to sort of answer your question about like, what more could you do, it's even explaining how, well, when we have sort of a high risk or a sort of crisis situation or moment, then different rules come into effect. These are those rules, and this is how they're applied. Again, all of that is not cleanly mapped out in a way that folks on the outside can understand, and it's even a struggle at times for the oversight board to understand it. And so I think, again, it's a learning process. There is some discretion that's always going to be there, but I do think making it simple, explaining the factors that are taken into account, but then also saying like we have 18 tools in the toolkit. This is generally how we're going to apply them. We add new tools all the time. Like it's going to be evolutionary, but even just explaining like what are the different kinds of interstitials and labels and all the different ways that they can go about slowing the spread of content is not fully explained in a clear way. And I think like understanding the nuance to the system is a first step. People are always going to misrepresent it and assume the worst, but that's oftentimes the best you can do.
Okay, so we're going to transition now to the next set of questions. The platforms are operating in the shadow of the law. They operate with some law already in place. Some states are experimenting with some laws, and some courts are weighing in on those experiments, as we all know. So we're going to turn to the way I phrased the questions. Is legislation advisable, constitutional? Can we trust the government to administer? And we've got Eugene and then Genevieve to open it up, and then we'll open it up to discussion.
Can I actually ask Genevieve to go first? She's actually worked a lot more than I have on this subject. So you should go first.
Okay, sure, happy to. And actually happy to go first because I think it's the last discussion we were having about the need for there to be consistent standards is a nice segue to the question of regulation. And Rick, I like the way you phrased the question because is legislation advisable constitutional? Can we trust the government to administer? The implication being the primary concern we'd have about government regulation or legislation. Well, there's the constitutional question, but then there's also this problem of political manipulation and abuse. I'm actually going to leave the constitutional question, since I get to go first, to Eugene. The short answer of is it constitutional is who the hell knows? Things are in flux, and so I want to put that secondary. I want to talk more about the normative question about is it advisable. And I'm going to make a strong and I imagine unpopular argument for this group that actually, given fears of political manipulation and abuse, legislation is not a bad idea. And so I'm going to make 3 points. Well-drafted decision. Okay, so so one is just to note, as I noted in my paper, that there is a long history in the US context, but also in other contexts, of there being extensive regulation, much more extensive regulation when it comes to the speech of political candidates than any other actor. Must carry obligations imposed on major speech intermediaries have long focused on sometimes other than, but also always exclusively, primarily on political candidates. And I think Nate, in his opening remarks, raised the question of like, what's so special about political candidate speech? We might think that there's a much broader array of speech, but the idea here being that this is, well, I think 2 reasons. One, which we've talked about before, that this is core to the democratic process, that voters need to know about the speech of the candidates. That to me, actually, I think that's a historically less central concern. I think the primary concern, but also obviously important, the primary concern has been this worry about manipulation and jawboning, essentially. That in the late 19th and early 20th century, there is a lot of there's machine politics machine politics by the end of the 19th century and comes to encompass the local newspaper, the owner of the local newspaper, who is very close friends with whoever the dominant political party is, who excludes rival candidates from airtime in the newspaper. And this produces a backlash, which is to say, we are really worried about those in power excluding the voices of those who want to challenge them, which is precisely the group of speakers who the First Amendment and free speech law has historically been most worried about from the newspapers. And this is why candidate speech is really important, because it's a useful way of not saying the government's going to control the operations of speech intermediaries generally. We think that's a bad idea. We want there to be some independence. But there's this electoral exceptionalism. I think Rick Pildes has called it. There's a special, very formalistic demarcation we're going to make, where we're going to say this is core to the existence of the democratic political process, and this kind of speech is really important, and impose all kinds of must-carry obligations. And I'll say, I mean, I think we forget about this today because we're used to the kind of libertarian ideology of freedom of speech, but for 100 years we've had must-carry obligations imposed. Newspapers the lightest, but broadcast radio, broadcast television, satellite television, and cable television. So all other major speech platforms, except for the social media platforms in varying degrees. Okay, so one, that's just the history. Two, the underlying justification here is that when we are worried about political manipulation and abuse, I think the assumption is that the way to prevent political manipulation and abuse is just to stop the government from regulating, from legislating, because that's government interference. But of course, we know that there's a lot of behind the scenes manipulation, and there's all kinds of informal and formal contacts and points of pressure. And so on the one hand, it is obviously true, and we've seen this in the history of media regulation in the United States, that poorly drafted laws can be used by innovative local actors and federal actors for all kinds of abusive purposes. But it's also true that if what we're looking for are consistent standards that bind the platform's hands so that they no longer have to make these difficult judgments, they no longer have to say to Senator blah, 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 or local mayor, who's more what's it, oh, wouldn't you just, do me a favor, this kind of speech is bad. They can now say we no longer have this power. By removing it to the role of regulation, it takes the discretion away from the platforms to potentially good benefit. And so I think if the primary concern we have is of government manipulation and abuse, it's not obvious to me that legislation is a bad thing. It could actually be very helpful. Now, there are, of course, other justifications for why we want to grant private actors discretion. And I was just noting them in the earlier discussion because it was a useful preview to this one. So there's this question of expertise. And there's the idea that we want a diversity of approaches. But I thought, so we want to have a full marketplace of ideas. We want to have a marketplace of marketplaces of speech, so we can have different speech norms in different communities or different platforms. Now, I thought it was interesting, the previous conversation, it seemed like the group was pushing against this idea that diversity in this arena is a good thing. That the invocation of human rights norms, the invocation of some norms suggests that actually, when it comes to the the opposite of Jonathan's non-viable, below the decency standard, we actually don't want there to be a variety of opinions. We don't want Paula to get to go and do its own thing. We want there to be some basic norms, maybe not with respect to TV. This is my earlier question. I'm not quite sure why the platforms are so special, but at least with respect to the platforms, we want there to be a minimum standard. So which suggests that, one of the major values of retaining discretion in private hands is off the table because we don't actually want there to be diversity. And then there's this question of expertise. And I think, again, the question of expertise can be handled through properly drafted laws where you can have a rule or a standard that binds the platforms, and then you can leave a lot of the operation of the sort of fleshing out of what it means to the first order decision makers with some kind of second order review. But that's my strong argument for why actually in this area, whether or not it's constitutional, regulation might not be such a bad idea. And it might be.
Putting aside that small question.
Can I ask a point of clarification though? And I was just trying to look this up because I don't know the exact details. Is it legislation done by like an act of Congress of which they have exempted themselves from stuff like hand spam and other things? Or is it more regulation coming from a government agency like the FCC or the FEC?
I mean, I think there's pros and cons, right? And the expertise. I mean, but I think this is a really interesting question about regulatory design. Like now we're in the arena of like, okay, if we are going to think about it, who do you want to be enacting it? I mean, I do think that there should be a constitutional rule that when a regulator regulates political candidate speech in a particular way or regulates how private speech intermediaries handle political candidate speech, they cannot exempt the body of which they are a part. That seems like a problem for the Can Spam Act. So, I mean, obviously that doesn't seem normatively desirable. If it's good for thou, it should be good for me too. I think, again, there's a trade-off between, on the one hand, democratic accountability and publicity. So when Congress enacts something, it is part, we know in a full-throated way, it's part of the democratic political process in a way that maybe FCC rulemaking is not as transparent or accountable. On the other hand, FCC has a lot of expertise. We might think as things develop, there may be the need for a lot more updating. But I mean, the way we've handled this is we have Congress establishes the broad standard, and then the FCC develops the rules, and that just, to me, doesn't seem like an obviously wrong approach. I mean, that's what we've seen with the Communications Act, where you have these broad standards in the Communications Act, and then you have quite elaborate rulemaking by the FCC.
Let's let Eugene weigh in, and then we'll open it up.
Yeah, so I think this is a tremendously interesting and difficult question. Is legislation advisable? I don't know. Is legislation constitutional? I'm inclined to say probably, but it's also it's not completely clear. Can we trust the government to administer? It depends on the legislation. I mean, for example, I don't care for the fairness doctrine, in part because it is, I think, leaves huge amount of discretion, which can be exercised in viewpoint-based ways. On the other hand, you can imagine some rules that are pretty easy to administer. So I'm going to offer two analogies, and there's an old Russian saying, "Every analogy limps." I think it may actually be borrowed from Latin, but it does. It does. If it were exactly the same, it wouldn't be an analogy, right? But it's interesting because in part, it raises a lot of the same issues. And it comes in the same sort of levels of possible breadth or narrowness that we're seeing with regard to social media. So one has to do with rules that require public access to shopping malls. They have been implemented as a matter of state constitutional law. I don't believe there are any statutes along those lines, in basically in 5 states, more or less. We can quibble about that. They've been upheld by the U.S. Supreme Court in Pruneyard. And the rationale, by the way, is very similar to what we're hearing about social media platforms. Like it used to be, everybody would congregate in the business district and walk down the sidewalks, which are traditional public fora. Now they're not there. Now they're in the suburban areas where they go to the big shopping malls. And it's important to provide the ability to speak to the public there on a fair basis. Because these private areas have in some measure supplanted the publicly owned ones. So the interesting thing is in 4 of those states, the rules, including our own California, the rule is basically that content neutral, that a shopping mall must allow people to go on the property in order to leaflet and gather signatures and such. And it must do so. It could impose time, place, and manner restrictions, but they have to be content neutral. So, for example, there was a case in which shopping mall wanted to exclude people who were protesting against a tenant, and the shopping mall said, "Look, this is contrary to our and our tenants' economic interests." And the California court said, "Well, too bad for you. You know, this is free speech, and we require you to do this." Interestingly, the 5th state, which is Massachusetts, didn't get there through interpreting its state free speech provision as lacking sort of a state action or dimension, more or less, oversimplified here. It did so through interpreting its election provisions. So as a result, it only allows people to go into shopping malls to gather signatures for qualify a candidate or an initiative measure for the ballot. So it doesn't actually allow speech by candidates, in part because probably a lot of candidates are really interested in going to a private shopping mall. But for signature gathering, this is important because that's a content-based, the viewpoint neutral right of access. So one possibility is you might say, okay, Pruneyard upheld the mandatory right of access. Maybe it has to be on a content neutral basis, though. Either allow everybody to speak or allow nobody. And maybe that means the Massachusetts rule is therefore unconstitutionally content-based. I'm inclined to doubt it. I'm inclined to think that the state should be allowed to treat candidate speech or signature gathering speech or ballot measure related speech differently. So that's one category of cases. And by the way, of course, Pruneyard is not the only one that upheld these rights of access. Turner Broadcasting, the FCC, did that with regard to cable networks, although it's complicated, not cable networks, cable systems, though it's complicated. Rumsfeld v. Fair did that with regard to universities and very limited right of access as to military recruiters. Second category, about half the states have, in one form or another, statutes that ban private employers from discriminating against their employees based on the employees' speech or political activity. Interestingly, a version of this, bans on discrimination based on voting, are actually the oldest employment anti-discrimination laws in the country. They date back to the 1830s, 40s, and 50s in some states, and now are present in almost all states. The bans on discrimination based on things beyond voting, generally expression about political candidates, date back possibly to 1868, where they were actually implemented first by military governors in the South as a means of trying to prevent it, basically the Democrat landowners from basically suppressing Republican speech, whether by freedmen or by whites. And then began further in the 1890s. I think the California one dates back to the 19-teens. Some were enacted more recently. So interesting, again, you look at them, some of them cover a lot of territory, though not fully content neutral. Connecticut, for example, bans discrimination based on speech, although subject to the Pickering balancing test. Colorado bans discrimination on any form of off-duty lawful activity, and courts have said, well, speech is one form of that. California bans discrimination based on political activity, which the California courts have interpreted quite broadly to include, for example, in the 1970s, advocacy for gay rights. But note, again, it's content-based. The employer is still free to fire you because you support the wrong football team, let's say, or something along those lines. Then there are some states that only, in fact, Washington State is an example, ban discrimination based on the campaign-related activity. So it's essentially supporting a political party or a candidate or a ballot measure or opposing a political party. So again, those are content-based but viewpoint neutral. I'm inclined to say they're fine. To be sure, again, they're even further removed because they're not about access to property, but they raise similar concerns about association. And employers say, well, we just don't want to hire Nazis. We don't want to hire communists. We don't want to hire supporters of Antifa or libertarians or whatever else. And in some states, they're perfectly free to do that. And in other states, the law says, no, that's an undue mechanism for leveraging your economic power into political power and to interfere with the political rights defined broadly or narrowly of your employees. Again, obviously differences, employer restrictions are probably much more powerful in suppressing speech in many ways. The shopping mall examples are interesting how that maps out, but those are examples of where, in fact, the law has at times, although not all state laws, distinguished campaign-related speech or political speech writ large, and provided protection for it from private retaliation as well as public.
All right, thank you for that. Nate has called an audible, and so I think what we're going to do, or an inedible, what we're thinking about doing is rather than breaking for 15 minutes to get our lunch, we'll go straight through and then end at 12:30, 12:40, if that's okay with everyone. So we'll take a few comments on this, then we'll turn to our last two speakers, Katie Fallow and Marianne Franks, to talk about the big question, how to deal with all of this in the context of the Trump case. But let's have a little bit more discussion on this. And let me just, before I turn to Katie, let me just ask Eugene, because you said you don't know if it's advisable to have legislation. Do you have an opinion on the Texas and Florida laws that are currently before, or one is pending on a cert petition and one will soon be pending on a cert petition, I think?
Sure. So my tentative opinion, and actually I'm glad you raised it because it allows me to mention something that I should have mentioned at the outset. My tentative opinion is that there are flaws in both laws. I think Florida has weird exceptions and weird categories that I think are probably improper.
The Disney exception?
That may qualify as that. Texas, I'm inclined to say that the law is likely constitutional, at least likely not a violation of the First Amendment, as to decisions about what to host and what not to host. And that it would be unconstitutional to the extent that it interferes with a platform's ability to decide what to promote and what not to promote, what to recommend and what not to recommend. Now, I realize that may actually be a distinction that is not a terribly sensible one as a policy matter. Others argue that it is sensible. I think as a free speech matter, that is where the line is drawn between compelled hosting, which is generally speaking constitutionally permissible in many situations, and compelled speech, which is generally not. So the analogy that I would draw is Rumsfeld v. Fair. So many people remember it because that's what the statute was, as a case about funding. That's not how the court decided it. The court actually said that we're going to allow the government to mandate that universities, regardless of whether they get funding, the mandate that universities host military recruiters, in part because it in no ways interferes with the university speech. And we'll also actually require the university, we'll uphold the rule requiring the universities as part of this no exclusion rule to distribute emails on the same terms about where the recruiters are, right? So you can't just say, okay, fine, we'll let the recruiters on, but we won't tell anybody what room they're in. But at the same time, again, the platforms are perfectly free to say, the university perfectly free to say whatever they want. So I think that's an important First Amendment distinction, whether, again, it's ultimately functionally useful, that university has to be free to say we don't approve of military recruiters, has to be free to put up a sign saying this recruiter is violating our non-discrimination policy and we only are allowing it because this is so. Could put up because of the rule, could be put up a sign saying this recruiter is below our minimum standards of decency and you shouldn't do this. Likewise, when they say, here are the top 5 recruiters of the 60 we have, these are the ones we think are the best ones for you as a matter of Yale values, or the best ones for you to talk to, I don't think the government could require them to include the military recruiters in that recommendation. So in that respect, I think some aspects of the Texas law may well be constitutional, although I'm open to persuasion to the contrary. But I think that it probably is a violation, at least of existing First Amendment rules. I should also say, by the way, I'm sorry, I wrote about 10 years ago a paper on for Google as a commission paper with regard to platforms' free speech rights in their recommendations. This may bear in some measure. I just want to disclose that I had done so acting as a lawyer, but this is my perspective as an academic.
Genevieve, do you want an intervention here before I turn to, yes?
Well, so I hear the distinction Eugene is making about speech versus hosting, but I think it's actually very difficult in the social media context because one might imagine that all content moderation decisions platforms making are expressive. Like I think Facebook in its community standard says we are communicating, we are creating a kind of environment for speech. And so the decision to not host is also an expressive decision. And so I think, I don't know, I feel like the analogy from Fair v. Rumsfeld, it's very difficult to understand when what we're talking about is a speech community that's intentionally constructed.
But I'm sorry.
Yeah, in part to communicate a message. I mean, I also do not like the Fair v. Rumsfeld case. But I guess I just wanted to add one other point though because I think, so I think what's so interesting when you look at the history of candidate laws and regulation in the US, the Florida law has been criticized extensively for many good reasons, including the Disney exception and all the culture war stuff and the bad intentions of the legislature. These are all good reasons. But in fact, if you just look at what the law is doing, it fits into a much longer tradition of treating political candidate speech as special. The problem, I think, with the Florida law, I think the Texas law is just vague, unconstitutionally vague, because it doesn't define what viewpoint discrimination means. But I think the problem with the Florida law is that the legislatures seem to think that they were bound by First Amendment standards when thinking about exceptions to the platforming requirement. And I think the great advantage of having legislation or regulation is that it doesn't necessarily have to be bound by the same standards. Like we look at the history of candidate rules when it comes to the Communications Act, the FCC has not felt like it has to obey First Amendment standards exactly when thinking about deplatforming. There has to be a general principle that applies to all actors. So I'm not going to weigh in again on the constitutionality, but I think the problem with the Florida law is that it sets up something very close to an absolute rule. And I think we all agree that an absolute rule of platforming is no good. That doesn't have to be the way you imagine the legal regime.
All right, so we'll take Katie. A lot of people want to talk, but we want to get to the last section. We'll take Katie, Daphne, then I'm going to let the last two speak, and then we can just have a free-for-all for the rest of the time.
Okay. I had 2 questions. One, on the advisability, Genevieve, what kind of legislation are you talking about? I thought your paper was really interesting in just like describing these other, precedents for equal access for candidates or, non-discriminatory access. So are you saying that you think it might be advisable to have some kind of, must carry for political candidates?
It should be.
About
30.
First Amendment, I love it. Yeah, I think so. I think there's a variety of options you could imagine. Like, I think the problem with the Texas and Florida laws is they've given a bad odor to this kind of regulation because of the context. But, you know, I think you could imagine, I mean, I actually think that there are interesting ideas in both laws. So the Florida law is just a very classic. We're going to treat political candidate speech as special, and that's got all these kinds of problems because it's a very formalistic distinction. The problem with the Florida law, again, is no exceptions, and I think we have to really think carefully about how we would want to limit that, but that's plausible. And I also think a ban on certain kinds of discrimination, like I think public accommodations law could easily be extended to the platforms, but that doesn't really get to the question about political speech because that's not within the scope of public accommodations. And so, you know, there are some jurisdictions, I think DC has included in its public accommodations law a prohibition against discrimination on the basis of political affiliation. And so you could have a rule that says you have to apply your speech rules evenly. We're not going to tell you what the speech rules are, but you have to show that they're being applied evenly. Or you could have a much more narrowly drafted sort of ban on viewpoint discrimination, where what we mean by viewpoint is promotion of a particular
hard.
candidate.
I mean,
Not
given
the easiest.
what we're talking about with your examples about pro or anti-trans, you know, hate speech, et cetera, I think that is. And I just want to have a question for Eugene, which is in the sort of pruneyard analogy. Do you think that that decision would be different if the people who were handing out speech or holding up placards had hate speech or nudity on those?
So hate speech, it couldn't possibly be different, because that would suggest that the Pruneyard rule, either from California court or from the US Supreme Court, is viewpoint based. And setting aside a few extremely narrow exceptions, such as incitement, which may be viewpoint based, First Amendment law prohibits viewpoint based rules.
So
California.
You could require shopping malls to have to allow people with signs with
In fact, California law already does. California law specifically says that that shopping centers can't even come up with content neutral rules, much less, content-based rules, much less viewpoint-based rules. As to nudity, it's an interesting question because, you know, there are all these weird erogenous zoning type cases. There was a case in which a shopping mall sought to exclude an anti-abortion protester who was displaying gruesome images of aborted fetuses. And the California court said, we say content neutral are the only rules you can impose. That's not a content neutral rule. So there's no doubt that if a shopping mall is required to allow speakers generally, then there can't be an exception for that. Oh, but racist speakers, you can exclude those. That's just not consistent with American First Amendment law. In that you can't have a legal rule that favors most viewpoints but excludes this other viewpoint.
Although there's a tension between that, saying it's not consistent with American First Amendment law, and what they were saying in Halleck, which is private property owners should be allowed to exclude speech with which they disagree on their property.
Well, so let me offer a slight, but I hope friendly amendment. So Halleck said, as a First Amendment matter, private property owners aren't required to allow speech onto their property. What happened in Pruneyard? California court said, as a matter of state law, to be sure, state constitutional law doesn't matter for federal purposes. As a matter of state law, private shopping mall owners, private property shopping mall owners are required to allow speakers on their property. The Supreme Court said that is not a taking of private property and does not violate the shopping mall owners' right not to speak. Because they can still say whatever they want to say. They can still refuse from, they can still refrain from saying things, but all that they're required to do is host. Those state law rules cannot be viewpoint based. If a state wants to have this right of access, it can say right of access except for people with really bad views, because that would be a state law rule that is unconstitutionally viewpoint based. It wouldn't just be a private property owner's rule, because it would be a state mandate.
I'm still skeptical that the court would come out the same if the facts have been different.
But I mean, it just seems hard for. I mean, at that point, the court had made absolutely clear that viewpoint-based restrictions are impermissible. The court has repeatedly made clear since then that there's no hate speech exception. It's hard to say how Pruneyard or Turner or Rumsfeld, although that had the special feature of it being government speech that's being required to be hosted, could possibly come out consistently with the rest of First Amendment law. Maybe they'd come up with some ad hoc exception, but it's just very hard to reconcile it with standard First Amendment principles.
All right, let's take Daphne, then we're going to go to Marianne and back to Katie to go to our last session.
So Eugene, what you were just saying plays perfectly into what I wanted to bring up, which is I think based on what you just said, the Texas law has to be unconstitutional because it is not a requirement to be viewpoint neutral for all posts. It has carve-outs where the platforms don't have to be viewpoint neutral as to two specified kinds of very awful but lawful speech. So one of them is a carve-out for speech that it sounds like it's a Brandenburg standard, but actually they can take down more speech than could be restricted under Brandenburg. And the other is a carve-out for it's like victims of sexual abuse being harassed and where the organizations identified the post, something like that. Anyhow, both of them target really terrible speech, but they definitely create special treatment by the state for, analogous to the hate speech special treatment and shopping laws that you said would be unconstitutional.
If they are indeed viewpoint-based, as opposed to merely content-based.
I want dibs on saying my second thing, though.
Question. I'm sorry. Happy to wait for your second thing. Sorry.
Well, I'm afraid Rick won't let me talk again.
Okay.
The second thing is that I'm pretty sure that the Texas law doesn't just require viewpoint neutrality as to hosting, but also as to ranking and recommendations. So I think it fails your test on that ground also.
Well, that was in fact something that I should have mentioned in the opening, and I'm glad I had a chance to mention later, and I want to re-stress. Yes, as to ranking and recommendation, my tentative view is that you can't require that. So the exceptions in the statute are for speech that directly incites criminal activity or consists of specific threats of violence targeted against a person of group because of their race, color, disability, religion, national origin, or ancestry, age, sex, or status as a peace officer or judge. So I think it's a question of how those are interpreted. So if directly incites...
Maybe we should do the second one, because I think that one is a harder...
Sure. Oh, the second one. So specific threats of violence.
No, sorry, the sexual harassment one, which I think is probably right below it.
So I'm sorry, it's sexual subject of a referral or request from an organization with the purpose of preventing the sexual exploitation of children and protecting survivors of sexual abuse from ongoing harassment. So I think, again, the question is what exactly is going on there? I take the sexual exploitation of children has to do with child porn. Well, but it's a fair question. So one possibility is the court may either say that provision is vague, in which case it's severable, or viewpoint-based, in which case, there's a question as to whether it's severable, or it might interpret it in light of the constitutional avoidance canon to focus only on child porn, but with kind of a prior restraint element. It doesn't have to be adjudicated.
There's another carve-out for illegal content. So this would be duplicative of that carve-out.
So it sometimes happens. So in any case, these are great questions. And again, that's one reason why, my article wasn't about here's the Texas law, here's the Florida law. I want to talk, and as I think Genevieve wants to talk about the bigger picture. But the specific statutes may very well be, the devil's in the details. Residential picketing statutes, so they're okay. Kerry v. Brown says no if they're written badly. Frisbee v. Schultz says yes 8 years later if they're written well. So it may be that the Texas law is invalid for these reasons, but I'm not sure.
All right, thank you for all that. So now turning to Nate to moderate the last panel. I think we're starting with Marianne.
So I'm not much of a moderator.
But you are after this moment.
Yeah, no, Marianne, take the time you need. And thank you for joining us with Zoom. Marianne, I should say, is a hero here that had very difficulty coming here for various reasons. And so really appreciative you came by Zoom. So turn it over to you.
Thanks. Can you all hear me okay?
Yes.
Great. So just a few thoughts based on this really fascinating conversation that has been ongoing. If I want to sort of take a very, very broad perspective here and talk about the way that the social media controversy, particularly as it relates to Trump, has highlighted, I think, in my view, the inconsistencies and the tensions in free speech doctrine generally. That's always been true. The kinds of myths that have been propping up a lot of free speech doctrine and practice, that this kind of debate really does I think, throw into very sharp relief. And in particular, this concept, this longstanding concept of the marketplace of ideas, I think really we're seeing how much of a mythology this really was based on these conversations. What I partly mean by that is there's an interesting political aspect, of course, to all of this, which is this entire conference, this entire question, and in some ways the most serious incentive for there to be legislative and other kinds of policy changes suggested for the tech industry and social media platforms has come out of this decision to remove somebody from a service, and particularly to remove President Trump from a service. That's interesting, I think, because the very same political powers that are so very upset about the removal of this individual used to be the proponents of the idea that the marketplace of ideas and the free market generally is the answer to everything, and very much emphasizing the kind of private liberty aspect of non-governmental actors. And that suddenly, when it goes in a different direction in terms of the power that is ultimately being assigned, there's newfound skepticism about this marketplace. And I think it's important to not forget that is maybe the key to understanding why certain aspects of First Amendment doctrine or free speech beliefs have shifted, are purely political in the sense that the far right Republicans have made clear, which is we only play by the rules when we win. That's it. And so for First Amendment and free speech, free marketplace, all of that, none of that is an exception to that basic philosophy, which is we only want the rules when we win. But what is that, is that useful? I think it's useful in the sense that we need to recognize that part of what the myth of the marketplace has done to us has made us believe that the first speaker or whatever speech happens to be in existence is somehow more important, more valuable, more free speechy than anything that comes after. That is, you have a speaker who says something, and then if there's a reaction in any way to regulate or to criticize, that second decision always gets a lot more scrutiny than the first decision. And specifically in social media, that's a decision to amplify, to grant access. Analogy to limp along, as Eugene suggested, might be to the debate around Confederate monuments, that you notice in the debate over Confederate monuments that there is a lot of agitation over the removal of Confederate statues. And what that narrative tends to gloss over is the story of how those Confederate monuments came to be there to begin with, the putting up of speech, the putting up of some kind of narrative is the thing that is turned invisible in some ways. And so even the title of this conference, the deplatforming concept, or the idea that there's a takedown concept, as opposed to asking questions about the free speech and other concerns about what we have chosen to amplify, what we have chosen to do with these structures. In the Confederate monument case, of course, as I know many of you know, the reasoning behind the establishment of those statues was to intimidate. It was to terrorize. It has a whole history. There are choices that are being made there that deserve scrutiny. And when we focus on the thing that happens in response to that, I think we get a very distorted picture of what not only whatever particular issue we're looking at, but also of free speech generally. It's something that I've wondered if we could refer to as something like an endowment effect or status quo bias when it comes to speech. When it exists, we think this is what is natural, this is what is unmediated, Trump doing what he wants to do on Twitter, that's somehow something we don't criticize and we don't challenge. And if someone alters that, that is the flashpoint for asking, are we doing the right thing? And I think that kind of framework does a real disservice to the concept of freedom of speech and to private liberty. So just a little bit more on that also maps onto what I consider to be the devaluation of the very key part of freedom of speech, which is the freedom not to speak and the freedom from speech. That there's a long-standing overemphasis on the kinds of things we think people should be allowed to say, as opposed to the very real and First Amendment protected right for private individuals to exclude, to ignore, to downplay, to criticize. And I think that what we're seeing repeated in this conversation is that same sense of sort of secondary, if at all, respect for that kind of action on the part of non-state actors, which is frankly to engage in as much viewpoint discrimination as they like. That there's something even about the phrasing of the state action doctrine that doesn't quite capture the significance of what should maybe be called the private liberty doctrine. That is, it's not an afterthought that the state is restricted and private actors are not. Private actors' ability to not have to speak, not have to associate, not have to amplify really needs to be seen as of equal importance and not as an afterthought. Why is that particularly important when it comes to Trump? Well, because in the sense that if we looked at the history in this country and in other countries, one of the only ways to fight fascism, to fight authoritarianism, is to engage in some kind of deplatforming, some kind of what it was called, I believe, strategic silence, at least according to historians, in reference to the KKK in the 1920s, where the KKK was a massive propaganda machine and was constantly trying to stage events and to get the media to pay attention to its terroristic tactics, and that many media outlets, especially Black-owned outlets, chose not to cover it and chose not to engage with it because they wanted to deprive it of oxygen. That there was here, again, one of those moments where you realize the kind of illusory effect of the counter speech that we've always been told is this magical kind of counterpoint to bad speech. It doesn't work, right? It doesn't work when we're talking about fascism. It doesn't work when we're talking about harassment. It doesn't work in any number of situations. Sometimes the only answer is really to exclude, it's to ignore, it's to not give oxygen to a phenomenon. And again, of course, we have plenty of reasons to worry about that if the government were doing it. But when it comes to private actors, it should be essential to our notion of freedom of speech, which isn't to say that there aren't problems, as many people have pointed out, that there are real risks and real dangers of having such powerful contemporary corporate influences controlling who gets to speak and who doesn't. That today it's going to be maybe someone we like getting excluded, tomorrow it's someone we don't. But I think the lesson to take away from that is not, oh, then we shouldn't support their ability to do that. I think the lesson to take away from that is the more we can convince ourselves, everyone around us, remind ourselves that these social media platforms are not public squares. They never have been. There is no such thing as a free marketplace of ideas. These companies do not care about our freedom of speech. They do not care about democracy. They care about profit. And that the more that we delude ourselves that we are engaging in free speech when we tweet, as opposed to engaging in a mediated corporate-owned enterprise that is maximized for engagement, which is another word for conflict, the more we can tell ourselves and remind ourselves that it's not free speech, it's not any of those things, the better. So what does that mean for solutions? I think much less of it has to do with ex ante conversations about what they should be doing with their policies or their procedures, and a lot more to do with getting people to reduce their reliance on social media generally, to become fully aware, constantly aware that this is a corporate enterprise and not delude themselves that it's something else, to try to put resources into actual narratives, actual conversations, actual resources that are in fact more geared towards freedom of speech and democracy. And I think, some of those solutions could include forcing these companies to charge so that we can make it literally visible to the public that these are not free services in any kind of sense, and to understand they're a product that is neither good nor bad in itself, but is something that they can choose to walk away from and choose to have to go to something else. And the other piece of it, I would say, is to change the incentives on the part of the companies. We can talk about, are companies worried about the bad press they're going to get for making this decision or that decision? And perhaps cynically, and I have worked with many of these companies, and when I say this, I want to emphasize that there are individuals at each of these companies that I think are extremely principled, extremely smart, extremely oriented towards trying to do what is right for the country, what is right for society. But those are at the individual level. As corporate structures, none of these institutions are invested in the kinds of things I think most people in this room, in your room, are concerned about. And so what really needs to happen, I think, on a very structural level is there has to be more and better opportunities for people to hold social media platforms accountable at the back end. And by that, I mean Section 230 reform, not for what they take down, because again, the takedown provision is already a weird way of phrasing what is just the liberty to ignore speech and to not amplify speech. But the part of Section 230 which says no matter what you put up, no matter how much you make money off of it, no matter how many people get hurt, you don't have to worry about it. That has to change. So if we really are concerned, as everyone should be, that these social media platforms have too much power, too much control over a discourse, we'll make it so that they are more like other industries and being able to be sued, to be held accountable, to be regulated, for the harm that they cause. If a kind of injury can in fact be made out, which of course is a high bar, even absent Section 230. So ultimately, again, whether it's the decision about Trump or not, it really is a crisis point for the theories of democracy and free speech that we have had. And it's a good opportunity to think about how much of the illusions of free speech that we have given ourselves have really been past their, have really outlived their usefulness if they ever were particularly useful. And now that we are facing an overt, organized attack on democracy in this country, of which Trump is a part, that we really need to take seriously the kinds of consequences of this illusion and to start thinking seriously about how it is that we can prioritize what is a question, nothing less than the question of whether or not fascism is going to get a platform or whether it's not.
All right, I think Katie, you're our last speaker.
Yeah. Thanks, Marianne. I think that's like really interesting, outside the box thinking. I'm more in the box. And I don't think anything I'm gonna say is surprising. I do think, Nate, what you said at the beginning, this is a very hard question. I do think that Trump should be replatformed for reasons I've already alluded to, namely that the process by which he was deplatformed, although I thought it was his having his account suspended in the immediate aftermath of January 6th made sense, but that I believe that social media companies should all come up with, YouTube included, prospective, transparent rules applicable to political leaders that, would apply not just to Trump, and that they should do it in a time limited. Any penalties should be proportional. Should start off with less restrictive, penalties if possible, using labeling and things like that. And with going, you can go up to higher penalties, but that the default should be erring on the side of leaving up the speech and to try to, as much as possible, focus on whether they violate particular rules against encouraging violence rather than personal distaste for the person's speech, even though I find Trump's speech like very dangerous and quite repugnant mostly. So as I said to someone else, my heart says he should not be replatformed, but my head says he should. But I also think that, as I mentioned in the paper that we did, that we're all talking about Trump, and there's a tendency to just focus on Trump so much. He's a lightning rod, and but that it also needs to account for the social media companies' own contributions to some of the harms for which they have been holding Trump accountable, and both in terms of being transparent about their content moderation policies and the ways in which their design decisions contribute to some of these harms.
So, and the design decision issue, and a lot of that came up in the oversight board's decision. So is your view that the initial deplatforming was correct, but at what point should he be replatformed, and what are the factors? Is it that we live in a country right now where the danger is not as grave as it was January 6th, so therefore he should be replatformed, or what criteria do you think or factors go into that decision?
I guess, my thinking is that their reasoning, and I know the platform's reasoning was different, but that it was very much focused on the events of January 6th and the concern about the peaceful transfer of presidential power. And I believe the real world violence harm from those events is not imminent in the way that it was at that time. I'm not ignoring all these other things, and reading his letter this morning and everything else, I think, okay, there is an overall sense of concern about violence and interference with our electoral process that I think we all share a deep concern and fear about. But I don't think it's just him. And we've also talked about that he's popular, not just because, he's popular, but 95% of the Republican Party supports him, despite everything he's said and done, including as to January 6th. And I thought, I don't know if this is what you meant but you were sort of saying we have a democracy problem, not just a social media problem. So I'm not totally convinced that whether or not he's replatformed is the material difference between the end of it.
Tending
You
either
go after
way.
Fox News.
Well,
You
they-
like-
well,
things
that's
that are threats
I-
to
you know,
our democracy.
You jest, but I think that is kind of an interesting question, which is to what is the independent impact of social media on pick your dependent variable, insurrection, decline of democracy, and the like. And so part of the difficulty here is that, you know, the paradigm for incitement is that you've got the mob ready to breach the building, and the inciter is saying go, right, or do this, or let's go get them. You know, we tend to think that or at least this discussion is suggesting that we think that it was clear on January 6th what they should do. But at what point on January 6th? Because, you know, if it's, you only know it's incitement when they actually breach the Capitol, which seemed totally outside the bounds of possibility at the time.
It didn't to me.
Well, the idea that the Capitol Police wouldn't have been able to prevent, I mean, I will tell you, I was on NBC at the time because I was going to do the, I was talking about the Electoral Count Act and all of that stuff. And literally I was there and this starts to happen. Chuck Todd saying, well, it looks like there's some disturbance, you know, and it's going, and then I'm sitting on there, I'm waiting for minutes now, trying to say what the Electoral Count Act says, what's the vice president's role. And then I tell the control room, it's like, this is beyond my expertise right now. You've got to get a national security person in there, right? It's like, you don't even know until the very unlikely disaster happened that it was actually likely to happen. Anyway, Evelyn.
Oh, sorry.
Yeah, go on. No, what were you gonna say?
Well, I was just going to say, like, where do you determine something's a legitimate protest versus going to turn violent? And I think that was some of the challenge with the Stop the Steal stuff and the difficulty of drawing the lines and parsing out what people are saying and what they might just be saying versus when is it actually turned, like you said, Nate, into actual violence is a really hard question for the platforms to try to figure out of when to do that. And flip that on its head to what was happening in June of 2020 with the racial justice protests and some of the violence and things that were happening there, making those determinations in real time. And it's all one of those things where like hindsight's 2020.
Yeah. It's actually, I mean, I think we should also, maybe I'm being too sympathetic to these folks. It is impossible to make these approximations. There is no like mathematical formula, like what is the likelihood that we are going to have violence if he is returned to social media? No one knows the answer to that question. If there was more violence in the streets right now, and that is why, you know, I put up on the slide the election that's coming up. I mean, if we have violence in polling places, it's like, all right, well, that's a good indication about how on the precipice we are, but it's kind of that we've already crossed it.
Yeah, just to support your point of like maybe we didn't know at the time. A wrinkle with the Twitter thing was that actually they suspended his account on January 6th. They didn't permanently ban him until January 8th. And the tweets that led to his ban were like, to those that have asked, I'm not going to the inauguration, which like if you're pre-reviewing that tweet, you're going to be like, that's not incitement. And then it was the fact that was interpreted both on Twitter and on other platforms to mean go attack the inauguration. I'm not going to be there. That was incitement. So it wasn't at the tweet time. It was only later based on reception of the tweet and things like that. So I agree that in terms of like evaluating at the time is really hard. Just one minor thing, as just to get on the record about whether Trump should be replatformed and when. An assumption that I was making was if he runs for and receives the nomination to be president in 2024.
Nomination? You say you?
Yes.
Okay, so we're then it's a year and a half then from now.
Right.
Yeah.
So if he becomes into that, we can debate how you define that category.
Yeah.
But if he goes into that category of political figures that should receive special treatment. If not, then yes, there should be a broader conversation about when do people permanently get banned from social media, and should there be like maybe nobody should, but that is a separate conversation that is about permanent bans and their proportionality, and Trump should be treated like everyone else in that category.
Jemai, and then David, and then Rick.
I have an uncomfortable thing to say, and as a guest who has been very happy in your country, I apologize in advance. I just, as an outsider watching this, it's been interesting to me because I think that these assumptions are honestly, they're very hard to make when you're from here. And that's why I used to work on hate speech because my country went through a series of upheavals, and I just wanted to understand. And it was interesting to me because every time I read sociological accounts of this kind of violence, there are clear indicators that it's likely. And I feel like the platforms should use them. That is, that there is a prevailing sense of disorder, and people feel like things are unstable. They don't see institutions and norms that they think they can trust. And part of that is electoral democracy. And another part of it is that political leaders, especially those holding power, give them validation for violent action. And so I think that if there's a way to step away from the discomfort and to use indicators, several of which have already been brought up, it might be possible to believe what we don't want to. If that makes sense.
Believe, and that is
The
the likely.
The likelihood of violence.
Look, I think I mean, I think there's high likelihood that we will have violence in this upcoming election. Okay, not more likely than not. I think, and you know, there always is some violence in an election, people jostling in polling places or the like. But certainly, there's a greater chance of violence now than there has been historically. I think. I mean, look at the. I mean, if you want a metric, just the number of election officials who've received death threats. I mean, it is. I mean, this is the area Guy and Rick and I operate in. It is chilling what's happening to them, and that's you are having a massive retirement of these election officials, the most experienced ones in the country, and so that's an indicator. Do I think would returning Trump to social media make that violence more likely or not? You know, it's not going to make it less likely. Yeah.
I think David was before.
Oh, sorry, David.
Oh, yeah. I just wanted to say I'm nowhere closer to understanding what I think the actual question should be, or understand the answer, because I mean, I think the question should be, although it's not as straightforward, but is what are the standards by which we judge whether Donald Trump should be returned to social media? And I guess I'm not sure what everyone agrees what those standards are. Is it just that we're talking about incitement, and then like below that, does it depend on who the inciter is? I don't have a good.
I think that's right. I mean, I think that's general. I mean, that's why I put up all the decision tree, which is like, yes, it is. I mean, look, we could throw other things in there about election denial, hate speech, and these other kinds of things. But insofar as most of the platforms are deplatforming him because of incitement.
Yeah.
I mean, it can't be just that we think he's, that the platforms don't like him, and so therefore he should be kept off. So we take that off. That's where the decency thing, I think, comes in.
Yeah.
But are the reasons that led to his deplatforming still enough to justify his continued deplatforming?
Yeah, right. So it's
hard.
Yeah. So, but it's good to come away from this discussion with a common understanding of, like, at least for this question, the standard is X. And then there can be diversity. I mean, human rights law is actually very open to diversity of outcome across contexts and jurisdictions. But if you start with that, then that's, I think, a positive. The one other thing that I just wanted to say, because I felt like in terms of the last discussion around legislation being advisable and constitutional, I think it's really important for us to recognize that this is already happening. I said this before, but I do think it's important for us to be, even in an American context, to be studying what is the DSA, the Digital Services Act, and how is it providing an incentive to actually answer precisely this kind of question, the platform's implications for social norms and so forth, and compare it to something like the UK's approach. Bless you. The UK's approach, which is much more, I think, problematic from sort of a free expression perspective, which is, well, what are the companies doing about disinformation or hate speech? But I really do think that we should be integrating those things that are already happening into our discussions.
I was smiling when you mentioned the DSA because I remember, as I always do, Daphne Keller's tweet thread or asking the entire world, how would the DSA handle this, right? The answer was, well, we don't really know.
But it wouldn't.
More transparent, I think, was the answer, right?
Yeah, right.
More legitimate somehow.
Right. I mean, the DSA. So that's. I mean, I mentioned it because it provides a legislative answer to this, right? Which is, we don't necessarily want government actors to be making these very particular decisions about particular actors, but we want them to do the, systemic risk assessment in advance, tell us what the rules are in advance, and then be transparent about the decisions they're making. That, that's based on a hope or an assumption that will lead to better decisions. It might be wrong, but that's the hope. And that's, I think, part of what, maybe an outcome or a next conference.
Okay. You tell me, we'll go down to
Yeah.
Southern California
Yeah.
because the weather here is just atrocious.
No, it's terrible.
God forbid.
California.
Oh my God. Yeah.
So, I'm much more in line with Marianne on the broader question. But if I was only focused on the violence issue, Nate was saying, like, you don't know that they're going to storm the Capitol. Well, I pretty much knew there was going to be violence when Trump tweeted November 18th, I believe it was, be there, it will be wild. And then there were further. That was the moment to deplatform to me. And, if he is replatformed, and I think given a Republican Congress likely coming in, given Elon Musk likely buying Twitter, given the political incentives for Mark Zuckerberg to kiss up to the new Republican Congress, he's going to be replatformed, I think, as a political matter and as a business decision. The question really is, and Nate, this was the first thing you said to me when we conceived of what this day would be like, is what's going to get him off the platform the next time? And I think the answer there is, and it goes back to Chinmay's point, when we see these indicators of violence, and the United States is not as exceptional as we like to think we are here. We're following a neo-authoritarian pattern like you see in many other parts of the country, many parts of the world. You can see where things are going. And so when there are vague innuendos, so let's take a recent example of Trump, when he said in response to the Mar-a-Lago search warrant, he said, something to Merrick Garland, like message to Merrick Garland, like, my supporters are not going to stand for this. There was this veiled threat. That would be enough to pull the trigger. Like in this context, there is a threat of violence.
I think Genevieve was next, and then Guy, and then Evelyn. Is that right? Yeah. Oh, I'm sorry, Eli. Yeah, Genevieve, Eli, Guy, Evelyn.
Okay, I just wanted to pick up on something Nate was saying earlier, which was about the fact that this is occurring at a time of essentially high, something called polarization, I think radicalization of the Republican Party, this incredibly significant divergence of understanding and it seems like increasingly strong anti-democratic or maybe fascistic tendencies among a significant portion of the population. So like, how do we think about, this is pushing against my general intuition, which is we just want to have generalized standards. We want to think about it sort of from a lawyer's perspective rather than thinking of the Trump case specifically. But I do think the Trump case raises this difficult question because as it's come up again and again, but we haven't really confronted it, a significant portion of the American electorate likes Trump and Trump affiliated speech. And it also means that Trump is not the only one who's engaging in this kind of discourse. It's huge number of confederates and surrogates and other media institutions. And so, okay, so on the one hand, that makes me think the fact that this is really a powerful set of speakers makes the kinds of concerns I was talking about earlier maybe less pronounced because, I worry about the little guy who's being shut out and Trump is a big guy. Maybe it's okay. Maybe it's better. We should, the stakes of deplatforming are not so great because he's going to get Fox News and Newsmax and Hannity and local blog podcasters. He's going to have plenty of opportunity to speak. But it also means just as a practical matter, like, is it plausible to imagine that the platforms are going to be consistent in their approach to this kind of speech, that they're going to deplatform not only Trump, but all of the other surrogates and institutions and intermediaries who are participating in the speech? And do we want them to do that? Because what would that mean would be that they're squarely thrust into a profound political and cultural conflict. And earlier, the invocation of platform neutrality was raised. Maybe there's a way in which you can think about this as neutrality, but you could also think about it as the opposite, that it's taking, maybe we could think for justifiably democratic reasons, taking one side of one side of the political argument seriously and rejecting the other. And I don't know how we think about turning platform. I mean, I think that is to some degree what the Trump deplatforming did. But then the platforms are, pushing against that. I don't know, is that a good idea? Is it a bad idea? I mean, a militant democracy advocate would say, yes, platforms should be advocates of militant democracy, and the fact that they're doing it is good. But I think it's complicated if we think about sort of radicalization that occur when a huge portion of the electorate is cut out of this important speech forum.
There's that Eli and then Guy, is that right? Yeah, Eli, Guy,
yeah.
Evelyn.
To pick up on Daphne's point on the DSA, I think it's going to be really interesting to see once that law goes into effect, how it's implemented and what works and what doesn't work. And like in a situation where Trump were put on a platform, and then sort of posts were taken down and then ultimately being deplatformed, he has certain remedies under the DSA in theory to invoke like a third party neutral body to then come render a decision, right? And look under the hood, and how that's going to work at scale. It won't. Like, I think there's no way to possibly operationalize that as currently constructed. But I do think it's going to be interesting to see how these cases, when they arise under the DSA, are treated, and what that does to inform then the way the US and other countries follow suit. So I'm fascinated to see, looking forward to Daphne and Kate Klonick and others trying to make sense of that brave new world.
So this is on the point of violence. So I guess the way that, as I'm listening to the conversation, I'm thinking about this, we have a huge problem of epistemic uncertainty, right? So like trying to predict and knowing what's going to happen, what is it that's happening, and how to do and think about it. We also have, and the problem of epistemic uncertainty is layered upon a framework of distrust and polarization, in which any decision that is made, unless there's a pretty clear sense of why it's made, is going to raise a series of recriminations, claims of bias, and might even lead to deeper polarization. Now, one of the things that violence does is that it provides a relatively bright line rule as to what the justification for the decision is, right? So it is hard because now you've decided after the China has been broken, right? But it's also makes for a very clear justification, right? So it's not like, well, this was going to happen, therefore, there's a reason why we did it. It is, in fact, it has happened, and now that is a justification for doing it. And that's also worth thinking about, the having a bright line basis. Yes, there are trade-offs, right? There's just no doubt about it, right? And it's an important and major trade-off. But again, the question is, can you solve the democracy problem by solely putting it on the social media intermediaries? And it's not clear to me that you can solve it. You can minimize it, but you can't solve it. And so this is a minimizing strategy, and it brings a certain set of trade-offs. But I think one thing to speak in favor of having a very clear basis, right? So this is, Evelyn's point of, look at the tweets by which they were deplatforming for. It was no different, right? Sort of goes to, what is the justification? This isn't very different. So having a clear basis, I think, has its benefits. And then one very quick point on, we've talked a lot about, there are lots of people who support hate speech or Trump or this or that. And I think two very minor points here, which is, Nate, you mentioned this in your slide earlier, deplatforming Trump really didn't, like, there was no, there were no riots in the street. If you're trying to think about, well, what is the lesson that we learned from that? One lesson, which could be a fair one, is it worked, right? And that's something that one has to reckon with. And then I think also supporting Chinmay's point that I think there is a difference between leaders and their followers, right? To what extent is the problem endogenous rather it is exogenous? What extent is that people really have these views and ideas? What extent is like listening to somebody like a Trump really create something? And I think those are also categories that we need to think about in the decision-making process.
And also, I think what you say, the probability that the speech itself will actually lead to violence, right? This is one way you could distinguish, someone with a large following from your average follower, but also, but this is where I start worrying about what this means in terms of deplatforming over 100 members of Congress who might be saying this.
Well, yeah, but you might say, Speaker, right, President is different from everybody else.
That's right.
Speaker of the House is different, right? I mean, you can begin to, those are defensible lines.
Yeah. Well,
maybe they're not.
Part of the question is it based on something about them, or is it about their following? Because if it's influencer, non-influencer, right? And so the question is, because that's what you would
Marjorie Taylor Greene.
Marjorie, that's exactly right. But not only that, but take someone who's even out of politics, right? So someone who's on Fox News or MSNBC. Evelyn, and then Katie. And Eugene, did you want? Okay, yeah.
It's not the point that I wanted to make. Just a really quick thing. I think it's more still an open question of how much deplatforming worked. How much of it is attributable to the fact that he was no longer president and therefore no longer just like as newsworthy, no longer covered by which deplatforming? Was it that he was deplatformed from the presidency or deplatformed from Twitter? And also considering the second order effects about this, like the increase in polarization, the increase in distrust in the media, the increased fractured media environment, especially if we started to see more widespread deplatforming of all of Republican election deniers. I think that that's a difficult question to, again, completely indeterminate. I think one of the open questions from today that I think we didn't talk about, one of the ones we didn't answer, apart from all those ones that we did answer, is the degree of American exceptionalism. So, I think, is the US different? Because if we're talking about like indicators of violence, if something is about like the fact that there's indicators of violence that justify these more extreme measures, then we should be talking about India, Nigeria, Brazil, the Philippines, many others that I'm sure I don't know about where these are factors, and the leaders in those countries, and what are we doing and thinking about those, which is a conversation that we haven't had so much either today or more generally, I think. And maybe there is like a US exceptionalism because they are US, sorry, there are people in this room that have had that
I was going
conversation.
to be like, I apparently can't be heard across the table.
No, I don't think we dug into it today. Of course, it was raised, but I don't think it was really talked about at length about this question of consistency. And is it important? And maybe the US is exceptional because they're US companies, and so they have a responsibility to the US that maybe they don't have otherwise. But maybe it could be the other way around, that as US companies, they should be more careful of their impact in other countries. I don't know, but I think that question is a really important one. To my mind, there should be consistency in order for legitimacy, and then that raises a whole bunch of questions about current inconsistency.
We've got our last.
Oh, yeah.
What?
Can I add something about the DSA actually? Is that...
Sure. And then Katie, you're gonna have the final word. You're gonna take us home. Yeah.
Okay, so I'm a visiting fellow from KU Leuven in Belgium. So on the DSA, it definitely there's so many things unknown, and we'll still have to see how it will play out. But there are certain elements there that I think it will clearly allow platforms, if they want, to keep him deplatformed, right? That they can do it on the basis of their terms and conditions, which should be clear and precise, but they can still decide what's in there. It does say that they should be applied in a non-arbitrary and non-discriminatory way, which they don't explain really what it means. It could be, for example, that there should be no special rules for politicians. That should be the same for everyone. For transparency, right? So the rules should be transparent. There should be statement of reasons if something is taken down or if the account is suspended, explaining why and explaining what are your appeal options, with a possibility to appeal, also out of court dispute settlements, although decisions of those bodies are not going to be binding. Right. So that's going to be also interesting to see what's the effect of that actually. There should be a recourse to court, which I think will lead to platforms being very detailed in their terms and conditions to avoid decisions like we've seen in Germany, where courts order content to be put back because it was not illegal, even though it was considered as hate speech under the Facebook rules. So there are all these elements there. They talk about temporary suspension in case of frequent manifestly illegal content. They say that mostly is for child sexual abuse content, but I can see how hate speech that is actually undermining democratic institutions could qualify as this as well. What else? I think interesting part is also the crisis protocols that that could be invoked in what they say in extraordinary circumstances affecting public security or public health. Those also should be temporary, but there's still so many things unknown that I think under the DSA rules they could keep him deplatformed. The question is, yeah, if they would want to.
Take us home, Katie.
I'm like trying to like narrow down.
your decades of experience dealing with political figures at a major platform, and what's the answer?
First, I agree with Evelyn, and I would push back a bit that deplatforming was successful, and I think that we could dig into that a bit more. But whether you look at Steve Bannon and the huge audience he continues to have, whether you look at the fact that Trump still is dominating the conversation completely around all of this, I do think that is a more worthwhile discussion to have, because I think other actors who haven't had those audiences, yes, they have less reach and stuff like that, but it is kind of hard to talk about this just in a vacuum. Two, Nate, you kind of opened with like, it's easier to stick with the status quo. I think the status quo is going to change very quickly, depending upon what does happen in the midterms, whether there's violence, like you said, whether Republicans take office. And I know we don't like to think about the fact that they have to take political considerations into account, but they do. They could sit there and be like, you know what, screw it. We're going to, we'll go to every hearing the Republicans do. We'll hire some people whose only job is to go get yelled at by Ted Cruz and others. And we'll do that because we don't think they'll end up being regulation, but that there are real consequences they have to take into account with that. And so I don't think we should think that the status quo today is going to be the status quo of a couple of months from now or after that. Last two things is just one, I feel like we've been kind of talking about the very short-term consequences of bringing President or former President Trump back. I do worry about globally, about the signal this sends globally and the ability for others around the world to utilize this, even though we know it's apples and oranges. And that's just, frankly, that was what tipped me into let him back with restrictions, because I was just so nervous about seeing how all these free speech laws and everything that have been doing it. Katie, I think you put it well. My heart says no, my head says yes. Like, it was just a really tough call, but I think we owe it to actually help kind of make a call as these platforms are thinking through it. And then finally, I just think that it's worthwhile as we think about this going forward, also having more of a conversation about those middle options like Renee was talking about. We kind of kept this very much in the binary of keeping them up or taking them down, and less about what should the consequences be around, are there other unique solutions that we could do in terms of thinking about solutions here. So I will leave it with that.
I'm glad we came to consensus and we answered all the difficult questions. This was a very helpful discussion. Hopefully it helped the people who have to make these decisions. And thank you all for coming, making the trip, and hopefully we'll come together under happier circumstances soon. Nate?
Thank you all for coming, and let's have lunch.
Yes.